Uh, I beg to mention, Madam, I'll maybe allowed to move one unlisted bail application, Madam, today, Madam. I've already filed, Madam.
Will be filed.
Yes, Madam.
Lordship, I may be allowed to mention one I in already disposed matter, Lordship.
Already disposed.
Yes, Lordship. Just one numerical numbers to be altered, Lordship, modified.
You filed miscellaneous application. Yeah.
Yes, Lordship, I filed already. Deeply applied.
Lordship, this item number 20 is wrongly listed today because on 28 it was listed and I have already taken the adjournment for this and 3 weeks time was already given in this matter.
20. Yeah. Miss Dear, Direct Counsel for the, you're for the appellant, the petitioner.
Yes, Lordship.
Petitioner submits that this matter has wrongly been listed as this by an order dated 28/7/2023. The matter is directed to be listed after 3 weeks. In view of the above, list this matter after 3 weeks. Okay.
Yeah.
May I please, Your Lordship?
Yes.
Your Lordship, I would like to mention item number 22, Your Lordship.
Item
22. Your Lordship, conducting counsel, Mr. P. Dapo is out of station, Your Lordship.
wait, let us see. This is only for referring the matter.
22, Your Lordship, item number 22, hearing.
That's
Your
what I'm
Lordship.
saying. 22 is for hearing.
Yes, Your
Okay, sorry. Criminal appeal.
Yes, Your Lordship.
Why?
Conducting counsel, Mr. P. Dapo is out of station. Out of station, Your Lordship.
Okay. You are Mr.
He may enjoy, Your Lordship.
E. Manjo. Submits that the conducting counsel, Mr. Pritam Tapo, is out of station, therefore pray for adjournment of the matter for 2
I'm
weeks.
taken consent. Yes, Your Lordship, 2 weeks.
But now he has also obtained counsel from the other side. Has prayed for, in view of the above, and has prayed for, list this matter after 2 weeks. Okay.
Highly, Your Lordship.
May I please, Your Honor? Your Honor, I would like to mention item number 7.
Yes.
Consent has been taken. Matter may be kindly taken after 2 weeks.
You are on behalf of
I am for the respondent.
respondent,
Yes.
Mr.
M. Doji.
M. Doji, line counsel for the respondent number.
All the respondent.
Okay, line counsel for all the respondents with the consent of the line counsel for the petitioner. Prays for adjournment with the matter for
After 2 weeks, madam.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
All right.
May I please, madam? I'd like to mention one criminal appeal wherein there is an IA for suspension of sentence pending. Madam. Here the appellant is undergoing hospitalized in the Trims Hospital. Madam. So in this regard, madam, we are filing an additional affidavit to bring on record medical documents of the appellant.
Who is under medical?
Appellant.
Who is under medical treatment, you said?
The appellant, the convict, madam.
Okay.
So there is a suspension of sentence along with the appeal we have filed, madam, that is maybe taken up tomorrow, madam. We are filing the additional affidavit.
Tomorrow, list already prepared for tomorrow. Tomorrow is Friday. We'll get it listed on Monday.
Monday, madam.
Okay. Monday.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 6. I am for the petitioner appearing on behalf of our sonar. So, due to some personal difficulty, conducting counsel is not able to appear before the Honorable Court. Therefore, I pray for adjournment. And I have taken the consent from the
You are
respondent.
Mr. You are Mr.
Mr. Karmi Bam, a petitioner.
K. Bam.
Yes.
Learned counsel submits that the conducting counsel, Mr. Rajesh Sona, has some personal difficulties with the appropriate for adjournment, to which the learned counsel
Your Lordship, kindly
Mr.
fix.
R. Ingo, sir, to which Mr. R. Ingo, learned counsel for the respondent, has no objection. The prayer is allowed. List this matter after.
Your Lordship,
When do you want? After 2 weeks?
sir, yes, Your Lordship.
Okay, after 2 weeks.
28.
20?
Yes, Your Lordship.
You want fixed date?
Yes.
2/8,
20 August.
20.
Yes, sir. Yes, Lordship.
Okay. On the prayer of the parties, let this matter be listed on 20 August. Okay.
Your Lordship, I beg to mention item number 2023. I'm appearing on behalf of L. Nochi, Your Lordship. This matter may be listed after 1 week, Your Lordship.
UFO
Petitioner, Your Lordship.
petitioner. Inform the other side.
Yes, I have taken consent.
You are Mr.
M. Tasso, appearing on behalf of L. Nochi, Your Lordship.
Mr. M.
Tasso.
Tasso, land counsel appearing on behalf of Mr. L. Nochi. Land counsel for the petitioner with the consent of the land counsel appearing on behalf of the respondent. Prays for adjournment of the matter for 2 weeks. The prayer is allowed. List this matter after 2 weeks. 2 weeks or 1 week?
1 week, Your Lordship.
Okay, matter. Let us make it 2 weeks. Okay.
Obliged, Your Lordship.
May I please, your lordship?
Yes. What is this? What is this section?
This is section, under section 439.
What is this?
This is a revision application, madam.
Hmm?
A revision application, criminal revision application.
No, what is this 439?
439 means that is power of High Court to recall and verify the lower court report.
Let us see. 439, oh?
439 of BNSS.
Okay. Kindly read it. What is it?
Well,
Power to?
power to order.
What inquiry is to? For what inquiry it is to be ordered?
On examination, any record under section 438 or otherwise the High Court of the session or Court of Session may direct the Chief Judicial Magistrate by himself or by any magistrate subordinate to him to make, and the Chief Judicial Magistrate may himself make or direct any subordinate magistrate to make order inquiry into the complaint which has been dismissed under section 226.
Further inquiry into the matter.
Yes,
Inquiry into any complaint.
my complaint was dismissed. Under same provision, even Court
Which
of
has been
Session-
dismissed under section 226 or subclause 4 of section 227. Where
Yes.
is?
But my complaint was dismissed, which was I filed under 138 NIA Act.
So then, why you had to come under this section? Why not under 538 or 482 of the CRPC or 528? Why not? Why under this?
My lord, there is no provision for revision in NIA Act. So it is said that under BNSS or CRBC is now modified to BNSS.
This was NIA Act.
NIA Act. I have filed my complaint, which was dismissed by the trial court under section one.
No, that is why,
Yes.
if there is no any provision under the NIA Act, why don't you come under 482 of CRPC or 528?
528.
This, I have seen, this is an unusual filing under 439.
Yeah.
I've never seen this. You have made state as a party.
Party, that is, no state party, say only sole respondent, that is private respondent.
Private respondent.
Yes. The dispute arose that I am the owner of the petrol pump. So from my petrol pump, the respondent.
Maybe.
Yes.
We're not concerned with that, but you have filed complaint.
Complaint, yes.
Okay, complaint was
Complaint
dismissed
was filed
for
under-
non-prosecution. Then why
Yeah,
under this 439?
Yes.
Yes, Mr.
My lord, regarding your lordship, 439 is a corresponding section of 397, my lord. It's a revision provision, my lord. 439, it has to be read along with 401, actually.
No, they have come against the dismissal of their complaint
Yes, your
for
lordship.
non-prosecution.
That is the finality, your lordship. The dismissal of the complaint is amounting to acquittal, my lord, actually. So they have to prepare appeal. Or otherwise, your lordship, if appeal is not there, then your lordship, the dismissal order is the final order, your lordship. It culminates the
Yes.
court cannot proceed further. Now it's amounting to final order, my lord. So final order has to be challenged under the revision provision. If appeal is not permissible, because it's a final order, only for the interlocutory order, my lord. If there to prevent the abuse of process, an intervention of court is indispensable, then in such case, to prevent the abuse of process, the court can exercise its inherent power.
Yes.
So this can come under power to order inquiry.
Your lordship,
439 is power to order inquiry.
your lordship, actually it should be under 438 and 442. My lord may kindly see the provision 438. Perhaps they have mentioned wrong provision, madam.
Yes,
438.
that is what I'm saying.
438.
438 and 442.
438, calling for record, that is
Yes.
correct.
And-
442, that's correct.
Yes, they both has to be read
Why
together.
439?
439, they have perhaps wrongly, your lordship.
That is what I'm saying.
Okay, my lord. I will be allowed to amend the,
You may have, you need to correct it. I mean, I think.
my lord, I may be allowed to amend the petition.
No, see, earlier you filed under 439 only, and then you made a prayer to correct it. And then the correction is also 439. You may have to correct it.
Yes.
You have to amend it and then
438 and 442, my lord. Okay. High Court's power of review. High Court power of revision, 442.
Okay. Mr. Decker, you Decker, Land Council for the petitioner. Submitted. And then praise for allowing him to correct. No, amend the court statute by inserting the correct provisions of law. The prayer is allowed. List this matter. When? Tomorrow? When?
I'll amend tomorrow only.
Okay. When this matter to
Matter
be
may be
listed?
listed after next
On
week.
Monday?
Monday, yes.
Okay, Monday.
Yes.
The prayer is allowed.
My pleasure, Your Lordship, this is the application filed under Article 227, with section 115. The civil result petition is filed against the impugn order. Your Honor, impugn order is in
page number 59, passed by the Deputy Commissioner, Kai Panyar District.
So this order was passed in execution petition.
In
You have filed
the
execution.
execution petition.
Okay.
In
Let us
the
see-
while
let us see the impugn order,
impugn order is, Your Honor, in page number 59.
where it is mentioned that it is, this order was passed in execution petition. This number is something different here.
Execution petition number is not given, but it is mentioned
Your
the,
execution petition was registered,
yes, execution petition number 1, it is registered as,
but this is not in execution petition number 1.
but the parties are mentioned here.
Parties are, but
Yes,
see, this is not in execution petition. Your execution petition has already been numbered as 1.
1.
This is not in 1.
But this, in the order, it is only mentioned the number of the order only is mentioned. The party, both the
It
parties,
says the agreement between the parties.
parties are mentioned here.
See, this order, it appears that what was passed in a consensus order, it appeared with the agreement made between.
Your Lordship, this agreement was never been made. This might have been and wrong, that has not been even whispered about in the decree. No such agreement
Who
has been
else is
made.
the party?
Party, Your Lordship, is in my page number 23.
Is
23. This is my execution petition. Clearly, name of the parties are mentioned in my course title, page number 26. Lika Amos. Lika Amos is the loanee, is the judgment debtor.
Okay, no. Here in this petition, who? Okay. There are 2 respondents,
Yes, sir. One is respondent number 2 is the grantor.
guarantor.
Yes, sir.
Okay.
Your Lordship, the impugn order has the Deputy Commissioner, while executing the
Will you issue notice?
Your interim order may be passed. Interim order, interim prayer is there.
Mr.
Because Your
Or
Lordship,
Mr.
K. Gara.
K. Gara, line counsel for the petitioner.
In the impugn order, Your Lordship, my decreed amount has been reduced. Whereas, Your Lordship, the executing
Is the reduced amount is only the principal amount.
principal amount.
Only the principal amount.
Yes, only principal amount. But in the decree, it has been included, my interest is also been included in decree. So, Lordship, the executing court does not have.
This application under Article 227 of the Constitution, we read with section 115 of the Civil Procedure Code 1908. Challenging the order dated 6/5/2025 passed by the in-charge deputy commissioner. Passed by the in-charge deputy commissioner, Kipanyo district. In how do we link with that? This is in the execution petition, but it is not numbered. Your execution petition has been numbered. Can we say that this was passed in the execution petition?
Yes, Your Lordship. Because Your Lordship, all the.
Where do we find the execution petition being numbered?
Page number 23.
2, 3.
Yes. execution petition number 1 of 25.
So this was numbered by whom?
Number given in the, your lordship, one receipt and
See. So, but this is not in execution petition. In, okay, passed by the petition, in execution petition number 1, 2025, white number KPT stroke YCL stroke JUD dash 01 stroke 2025. Whereby the decreed amount. What was the amount
9 lakhs, your lordship, 9 lakh
of rupees 9 lakhs
9 lakhs 60,000.
50,000? Where is the
9 lakh 36,000, your lordship.
where is the order
It is in
page?
your lordship.
Kema order
Decree order is in page number 18 to 22.
18.
Page number 18 is mentioned in your lordship in page number 19, your lordship.
19.
No, your lordship, I'm very sorry, your lordship, in page number 20. In page number 20, in order that serial number 2, clause
Okay.
A, 9 lakhs 36,000.
9 lakh 36,000 to 3 lakh 60,000. To 3 lakh 60,000. The main ground urged by the petitioner is that the 60,000, 3 lakh 60,000, which according to the learning counsel for the petitioner is the which according to the learning counsel for the petitioner is that the learned executing court has exceeded jurisdiction in execution petition. In execution petition. So the learning counsel for the petitioner submits that the execution court cannot go behind the decree or alter the terms of the original order passed by the competent adjudicating forum. Here in the instant case, the who has passed
Your lordship, decree was passed by the village customary court, Yazali.
in instant case, the village customary court. Where do we find
It's page number 18, your lordship.
the village customary
Head under the chairmanship of head Gaubura Yazali.
court? Yazali. Page 18. Passed by the customary court. Yeah, customary court, Yazali. Key banyo. Okay, so issue notice. Call for the relevant record. Para issue notice. The petitioner shall take steps upon the respondents by a registered post with AD as well as by usual process within a week from today, stop. List this matter after 4 weeks, stop. In the meantime, the impugn order dated 6/5/2025 passed by the in-charge Deputy Commissioner P. Banyo District, Yachuri, in execution petition number 1/2025 by number KPD from YCL stroke JUD -01 stroke 2025 stroke 2756 -59 shall remain state till the next date of till the returnable date. Okay. Oh. Nice.
Lordship, item number 3 and 4 is similar, but Lordship, item number 4, maybe take up first.
Similar.
On item number 3, Your Lordship, we have raised an issue of maintainability because they prefer an application under 528 invoking the inherent power of this court, Your Lordship, wherein the FIR clearly disclosed the commission of cognizable offense.
Whether the charge sheet already filed?
Already filed, Your Lordship, the cognizant charge has been framed, my lord.
No, no,
Sorry, cognizance has already been taken, my lord.
Cognizance taken.
Already been taken. Now their plea is, Your Lordship, in absence of prosecution sanction for UAPA Act, the court cannot
Take
proceed.
cognizance.
Court cannot take cognizance, yes, Your Lordship.
Sure.
So now, basically, if we see, Your Lordship, they have 528, but we have to understand one aspect, my lord. For 528, if they are challenging the FIR, then they have to satisfy this court that FIR does not disclose commission of any cognizable offense. Only to that extent. If they succeed, it will be quashed. If they are not succeed, it will be dismissed. But for the subsequent stage, if they are challenging the cognizance order, Your Lordship. So cognizance order, my lord, according to the settled law, as settled by the Honorable Supreme Court, it is no doubt this interlocutory order initially. But however, when the impugn order or the interlocutory is reversed, and such reversal is result in culmination of the main proceeding, then that order will be an intermediate order. So when it become an intermediate order, it has to be challenged by way of revision, not under 528.
That is right.
So here, this is the issue, man.
My lord, I'll just clarify.
Because you are agreed by.
I'm agreed by two account, my lord.
Yeah.
Not only on cognizance. Cognizance letter is a consequential action of the charge sheet, my lord. I'm challenging the very validity of the charge sheet itself. When the charge sheet is in violation of statutory rules, it is illegal, my lord. I'll come to the detail in provision, my lord. The charge sheet is illegal since it has been filed, has not been complied with the statutory provision. And on the basis of such illegal charge sheet, no cognizance could have been taken. And the cognizance has been taken. So I'm challenging here with two aspects, not FIR. FIR is the basis of investigation. But after FIR investigation, the law says that whatever investigation material you have collected during the investigation, that has to be reviewed by the independent body appointed by the authority under the law. In this case, the independent committee has been appointed, nor it has been reviewed by any independent committee, madam. And now that extends, madam, to that apart, that the charge sheet itself is null and void and illegal, madam. Charge sheet, it's illegal. And there's when it is illegal, this could not have been taken cognizance, madam. Now there's a cognizance for taking cognizance, there's a bar, madam. Bar for non-prosecution and for obtaining prosecution sanction, But in this case, not only the case of prosecution section, but even the charge sheet has not been approved, reviewed by independent body. And after reviewing independent body, it can be recommended to authority for obtaining prosecution section. Now, the first, the stand, the charge sheet itself is illegal and based.
So under such case, the charge sheet is to be reviewed by the independent body.
Yes, yes, my lord.
That independent body like,
Yes, my lord.
independent body like,
Independent body, my lord, they have to appoint, my lord. I'll just show the provision, my lord. First thing, my lord.
Only for UAPA, my lord.
Only for-
That I will correct, my lord. Only for UAPA.
Only for,
yes, that.
There are other sections are also there, my lord.
yes, that is there.
That I will.
That's, I'll come to the point, matter also to clarify that when it is under a particular provision, my lord, there's a investing the power to the particular the court, my lord. Consequential other the provision of law which is connected to the UAPA and other special act will that can also be not be tried by that special court, my lord. That I'll come to that point also. But the first coming to the my lord, see, first FIR was registered among other section, my lord, section 13 of UAPA Act.
Just let me see that. What is your prayer? Let me just see once.
My lord, I've charge sheet and the cognizance taken care of. My lord. Since madam, section 13 is there, madam. So the vital point to be discussed is on the section 13 of UAP Act, madam. And other is clubbed along with this UAP Act. Now, primary, the section, madam, primary main, the section is primary section act is UAP Act, madam. This because of UAP, this all along with other section has been attracted, madam, has been booked, madam. Now come to my lord, I'll just take reference of section 45, my lord, of UAP Act now. Yes, madam, section 45.
So the government of cognizance.
Yes, madam. Cognizance of offense, section 45. No court shall take cognizance of any offense, my lord. A1 under chapter 3 without the previous sanction of the central government or any officer authorized by the central government in this behalf, my lord. Clause 1, madam. Now subsection 2, my lords. Relevant to this case, madam. Sanction for prosecution under subsection 1 shall be given within a such time as may be prescribed only after considering the report of such authority appointed by central government or, as the case may be, the state government, which shall make independent review of evidence gathered in the course of investigation and make recommendation within such time as may be prescribed to the central government or as case may be the state government. Now, my lord, the first part, cognizance part, first part, clause 1, my lord, subsection 1, clause 1, under chapter 3. Section 13 falls under chapter 3. That's chapter 3, my lord.
Chapter 3 of?
UAP Act, my lord.
Okay.
This is under chapter 3, my lord. Section 13 is under the chapter 3, my lord. Now, for this, my lord, there's a bar under statute not to take cognizance if the offense relates to under chapter 3 without previous sanction from the central government. Now, my lord, what is the procedure for granting prosecution sanction? It is under subsection 2, my lord. Now, subsection 2 says, my lord, whatever investigation, allegation pertain to FR registered in connection with UAP Act, my lord. Whatever material collected by investigating agency has to be reviewed by independent committee to be appointed by the central government or state government. Now that committee has to review whatever evidence material they have collected during the course of investigation, whether to decide whether as to this case can be recommended for obtaining sanction, granting sanction from the competent authority or not. Now that the committee, independent committee will look into. But in the present case, this committee was not even appointed. And not therefore question of even review doesn't arise, even no review was made. Because why, my lord, the independent committee was not constituted? In violation under section 45.
So under this provision, that means the independent review, will make an independent review.
Yes. This has to be constituted. Now, and there further, my lord, there's a provision. Time frame, my lord. This in the act, my lord, time frame has not been mentioned, but this has been clarified in rules, my lord. Within 7 days, this has to be done, my lord. Subsection 2, my lord, to say, within such time as may be prescribed by the central government or the state government. Now, this time frame.
Who in the under as per this provision?
Who's the independent body?
Constituting the have to constitute independent review or just who is the authority?
My lord, that is the authority government. They have to constitute, my lord. That is
Unlike in the PCA section 13, prosecution sanction is by the government, but here independent review,
and for
of the evidence.
Yes, my lord. For this
So
purpose,
where do we find that the committee is to be
my
constituted?
lord, this purpose under this subsection 2, they have to constitute a committee.
There should be permanent committee.
Yes. Whatever
State don't have.
Yes, whatever any offense or investigation case pertaining to UAP Act, there should be a committee. There should be a committee, my lord, that they will look into all the whether to be recommended for granting prosecution sanction or not. If they draft, if they do not.
In this case, it was not done.
Yes, it was not done, my lord.
It was so unless this review is done.
Yes.
Recommended for prosecution sanction granted, so Cognizance could not have taken.
Yes. Charge sheet could not have been acted upon because illegal charge sheet it is in violation of rule, my lord. This charge sheet could not have been taken into account, my lord, because illegal, null and void, my lord. My lord, further this subsection 2 refers to subsection, my lord.
Now, after taking cognizance, what is this case? The status of the case, whether it's framing for
Not framing. It's pending, my lord. It has not yet been done, my lord.
Not yet been done.
Yes, it's pending, my lord.
How many accused persons are there?
Uh,
You are praying on
My lord,
Half
two
the-
accused person.
Only two accused persons.
Only two. So far, two accused person has been arrested, my lord.
Okay, both of them.
Yes,
challenged.
yes, my lord. Now, my lord, with reference to subsection 2 of section 45, my lord, the rules is there, time frame, my lord, even time frame also. Time frame, this cannot be, that is not the case that after.
And it appears that you have also made party to the informant.
Yes, I made my party to
Whether the
informant.
informant was, notice was served upon the.
My lord,
informant.
informant, my lord, they have not yet served a notice, my lord.
No, any order passed. The informant.
That
needs
is,
to
this is
know-
why my lord will issue notice to the informant, my
My
lord.
lord, may kindly hear us, then pass issue notice on this
Okay.
matter. Because this is for the second time this matter is
That
listed
is
for
why,
motion.
in the initial stage, no notice was issued.
No notice
Yes,
was
Your Lordship,
issued.
because Your
When it should
Lordship,
have been issued.
we has raised an issue on maintainability.
Maintainability.
Yes, Your Lordship. Now, Your Lordship, let my brother complete, then I will come.
But even if, before passing in on the maintainability also.
That can be done, Your Lordship. Even for maintainability, notice can be done,
Right,
and we
right.
can argue on the
Right,
next
right,
stage also.
right.
But Your Lordship will just clarify
Yes,
some.
yes. Okay,
some
let
law
us
aspect.
clarify.
Yes.
That's.
Now, my lord, see, in reference to subsection 2 of section 45, my lord, rule has been framed. It is not a case that after filing charge sheet, this can be cured even after taking cognizance. It is not. It cannot. It is not curable, my lord. One. That's within 7 days after completion investigation, they have to submit to the independent body who will scrutinize make scrutiny of the evidence gathered by the investigating agency for the purpose of recommending for obtaining prosecution sanction. Now, time limit, my lord, next rule 4. Now that the government on recommendation, my lord, time limit for sanction of prosecution. Central government, or as the case may be, the state government shall, under subsection 2 of subsection 45 of the Act, takes a decision regarding sanction for prosecution within 7 days after receive a recommendation of the authority. This is, my lord. After completion investigation, whatever material they have gathered during investigation, that is to be submitted to the independent body who will make scrutiny and recommend. It's fine fit, then they will recommend to the government for granting sanction. And according on receipt of recommendation, the government competent authority will grant a prosecution sanction within the 7 days. This is, my lord. Now, in this case, my lord, since this entire provision has been plotted, my lord, and this part cannot be cured, my lord. Now, basing on this illegal charge sheet, my lord, this proceeding could not have been taken. There's a specific bar, my lord. In this regard, my lord, Bhajan Lal case, my lord, it is, as of now, it is landmark judgment, Bhajan Lal case, my lord, holding the field, my lord. When there's a statutory bar, my lord, then it is a fit case to be excised under 482, my lord. Now, 528, my lord, this. Now it has been clear, this is squarely covered under these Bhajan Lal case, my lord. Para 102, clause 6, my lord. My lord, just from starting, I'll just read. In backdrop of the interpretation of various relevant provision of the code under chapter 14 and of the principle of law enunciated by this court in series of decisions relating to exercise of the extraordinary power under Article 226 or inherent power under 480 of the Code, which we have extracted and reproduced above. We give the following categories cases by way of illustration, wherein such power could be exercised either to prevent abuse of process of any court or otherwise to secure end of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently generalized and inflexible guideline or rigid formula to give an exhaustive list of merit kind of the case wherein such power should be exercised. My lord, among other, we'll see at clause 6, where there is express legal bar engrafted in any of the provision of code or the concerned act under which the criminal proceeding is instituted, to the institution and continuance of the proceeding, where there is a specific provision in the code or the concerned act providing efficacy redress for the grievances of aggrieved party. My case here, there is clear-cut explicit bar under statute for taking cognizance, and even the charge sheet, my lord. Charge sheet is illegal, my lord. In that case, my lord, the 482, that is corresponding to 528, is maintainable, my lord, undoubtedly, my lord. (2011) SSC also, my lord. Para 51. Para 51. This court had an occasion to examine the legal position in a large number of cases. In R.P. Kapoor versus State of Punjab, this court summarized some categories of cases where High Court in its inherent power can and should exercise to quash the proceeding. Number 1, where it is manifestly appears that there's a legal bar against the institution or continuation of the proceeding. In my case, legal bar. Therefore, 528, which is akin to 482, it is maintainable, there's no doubt, And 53 also, and the same. The continuation is the abuse of process of law, because when it is evidently clear, it is seen that this charge sheet has been filed in violation of statutory provision. Now, basing on this illegal charge sheet, no cognizance, the proceeding could not have been continue, And regarding interpretation of Section 45, of UAPA Act, other several High Court has also clarified, even interpreted to the extent of intention of incorporating Section 45 UAPA Act, because it is of stringent action, or the provision, there's a possibility of misuse by the investigating authority. That is why, purposefully, the primary intention of the legislature was to reevaluate and to scrutinize the evidence gathered by the investigating officer. It should be reviewed by the independent body, There is even to that extent, the intention of the legislature was detailed discussed, my lord, in one of the case by the Odisha High Court, my lord. Why this is mandatory? To the extent right from the beginning of introduction of when this bills was introduced, my lord, section 45 was discussed at length, my lord. To London Council for President for quash the criminal proceeding initiated against the petitioner Entrella on the following ground.
This is your reading paragraph 4.
First, my lord, the first starting two.
Para 2.
Amongst other following certain ground, and amongst other, my lord, one of the ground is sanction is not valid sanction, my lord. In my case, there was no sanction at all, but they have in this case the question of valid sanction, my lord. Amongst other ground, B, my lord, valid sanction. Amongst one of the ground was valid sanction, not having granted valid sanction, my lord. Now, for my lord, although various contention were advanced in course of the argument, this court's view that the contention B as noted here above would be dealt with at the outset, since the determination there would be vital for the purpose of ultimate outcome of case, and the contention may not be required to be determined, and other contention may not be required to be determined. Now, 6, my lord, for better appreciation of section 5 UAPA is quoted here and below. That is what exactly reproduction of the act has been reproduced. Now, Fera 7, my lord, the history of this act, my lord. The London Council for the petitioner asserted that incorporation of the requirement for appointment of an officer to conduct independent review as incorporated to subsection 2 of the section 45 of the act serves a very important purpose. The prosecution under Unlawful Activity Prevention Act is an extremely stringent law. Parliament provided safeguard to avoid the frivolous prosecution. It is asserted that in the present case, the state of Odisha has not made appointment of any officer to carry out the independent review. And further, there has been no prescription of any time limit for making the necessary recommendation. In absence of the appointment of the officer to conduct independent review or prescription of any time limit for making recommendation, it is contended that a sanction in the present case not a valid sanction in law. In the present, in this aspect, the London Council for the Petition placed reliance upon the speech of Honourable Home Minister while moving the draft bills in the Rajya Sabha. And in his speech, the Honourable Home Minister clearly stated that the legislative intent behind the section 45(2) of the Act was for creating an independent executive to review the entire evidence gathered in the course of investigation and then to make a recommendation whether the case was fit for prosecution or not. This was prescribed by the Honourable Home Minister in order to filter and buffer such independent authority who was required to review the entire evidence would provide the very salutary safeguard. Such an authority independent from the investigation was the biggest buffer against the arbitrariness, madam. Madam, this is how the basic intention behind the legislature, madam, that has been highlighted. And according to para 10 last, madam, in view of above conclusion, finding reached here above, this court is of the considered view that no cognizance could have been taken against the petitioner in absence of any valid sanction of the prosecution. And in this regard, although the sanction for prosecution had been obtained, yet same was not based upon review by the validly appointed authority to carry out independent review of evidence obtained in course of investigation. Therefore, the very foundation of the obtaining such sanction being not in consonance with the law, the order of cognizance dated passed by so ought to be quashed, and this court direct accordingly, according that cognizance was set aside and quashed.
Okay, we'll continue to then.
Yes, ma'am.
Yes.
Even actually, there's a revisional problem, even in that amount, inherent power is extraordinary power. But well, exciting revisional power, it cannot enforce the more than what's honorable subject to the but inherent power is an extraordinary power and it doesn't pass. In this, even if there's a revisional provision, as possible, assuming the order is to be, even in that case also, in order to secure the end of justice matter and prevent abuse of course of law, inherent power. But in our case, it's landmark this one, Ivan for productivity. Inherent power of the High Court is not conferred by statute, but as merely been saved thereafter. It is thus difficult to conceive that jurisdiction of the High Court will be able to would be held to be barred only because the revisional jurisdiction would also be available. Assuming even yes, that is revisional power jurisdiction, but that would not be wrong to oust the inherent power of the High Court. Now, relying on this manner, the Constitution bench that is clarified this point that this case arising out of Rajasthan High Court. The Rajasthan High Court, taking the same state as proposed by as in this case, that this order is to be revised with their original education license. Therefore, 482 does not like all these this proposal criminal petition was dismissed. Against which went to assembly the Constitution bench for considering this aspect. Relying on product limited, recent the previous relying on that provision, the decision of the product. This the Constitution bench has clarified this aspect. Mr. P.K. Kwasami, Lawrence Senior Advocate Court, supported the brief taken by this court in Dariwal production. Just now I found. So he pointed out that in the paragraph 6 of this judgment, Justice Sholso took note of the several earlier judgments of this court, including R.P. Kapoor versus State of Punjab. Coming to the conclusion that only because the revision petition is maintainable, the same itself would not constitute a bar for entertaining an application under Section 482 of the Court. Mr. Short was there's a strong reliance upon the judgment of Krishna here. This is under the previous judgment reliance upon that. Now there are 6 months. In our considered view, any attempt to explain the law further as regards the issue relating to inherent power of the is uncovered. We will simply repeat that Section 482 begins with non-obstante clause to state that nothing in this code shall be able to limit or affect the inherent power of the High Court. to make such an order as may be necessary to give effect to any order under this code, to prevent abuse of process of any order under to secure kind of justice. Personally, there can be no total waiver outside of such all such jurisdictions where, in words of Krishna Iyer, Justice Krishna Iyer, abuse of process of the court or other extraordinary jurisdiction as sufficient. Aside the force jurisdiction, the limitation is self-restraint, nothing more. We venture to add further reason in support. Since all the 397 CRPC is attracted against all order other than intellectual, a contrary view would limit the availability of the inherent power under Section 482 of CRPC only to fitting intellectual order situation wholly unwarranted and unjustified. As a sequence, we are constrained to hope that the division bench, particularly paragraph 28, the case of Mohit Lal Soul and other learned super in the case of inherent power of the High Court in Section 482 of CRPC does not state the correct law. We record our respectful agreement, disagreements. In our considered opinion, the largest single judge of High Court should have followed the law laid down by this court in Dhariwal High Court Procedural. Just I refer to Supra and other earlier cases which were cited, but wrongly ignored and the reference to the judgment of that which in case of Sajid Angadi were asked to another largest single judge is also in social, which is reviewed social. As a result, the appeal one preferred and other candidates are allowed the appeal for all judgment and order passed by the High Court and set aside. The matter are remanded back to the High Court for fresh hearing of the petition under Section 4. In light of the law explained above, for disposal method, but this is initially 482 petition was filed, and on the ground that this revisable order, the criminal petition are 482 was dismissed against the SLP. The SLP is reiterated the law laid down in the case of Dhariwal tobacco product, and that is that we should have been should be considered or made. And similarly, recently also in our High Court, well, starting for the same UAPA was set aside for Salary of 20, 2024, there are 11 this the law has been reiterated as one now this is also an exercise of our merit law. Section 45(1) of UAPA and that no court can take obligated to operate under Chapter 3 of the UAPA without previous sanction of central government or any officer authorized by the central government. The Parliament, in its wisdom, has incorporated such provision and also created independent authority to review the proposal for prosecution sanction. It is by now settled that such procedural safeguards have been described to protect the accused from unwarranted prosecution and trial. Inasmuch as the provision of UAPA is praised. Therefore, in the considered opinion of the court, such provision is an additional safeguard. 11. Thus, such sanction is required to allow the court to take cognizance for offence, and in absence thereof, court cannot take cognizance to and not to say proceed further and frame charges. Well, law is now well settled that such sanction must be well sanctioned, and sanction under Section 45 of the European is condition precedent for empowering the prosecuting agency to approach the court, so that court can take cognizance of offence under Chapter 3 of the European Act. Thus, the court shall get jurisdiction to try a case against any person for the commission of the alleged offence under Chapter 3 of the European Act by taking cognizance only when there is a prosecution sanction. One of the reasons for providing such condition, in the opinion of this court, is that the provision of UAP Act 1967 are rigorous and penalty provided is more strengthened compared to the offence under RTC. Therefore, such procedure or sanction has been introduced and independent review committee has been created to safeguard citizens from any vexatious prosecution under UAP. Therefore, the court cannot take cognizance of the offence under chapter under part 3 of the European Act unless there is a valid sanction accorded by the competent authority as prescribed in the European Act.
Okay, okay.
Madam, this is the similar matter to the case, madam, the one exactly the other court, the charge rate has been set aside in the past. And with regard to the other part,
Here in this case,
yes,
charge already framed,
this charge only different, it was set aside.
but it was set aside
Yes,
only because there was no.
yes, yes.
Okay.
Para 26 matters. Thank you. Accordingly, without having any order of sanction, without having any order from the level section, succeeded in its jurisdiction in passing order of credit card. Accordingly, impute order letter passed the level section.
Here in this case only under the UAP, or there was also offense under, okay.
Yes, on UAP.
Okay, no offense under
Yes, other section.
other sections are there. Okay.
Okay.
Yes, here in this case, what about the other section?
Other section, other section, Honorable Supreme Court says that when there's a special act empowering a particular court to take cognizance and grant, and if it is that part, it is empowered by the special act, then proceed with the further trial with the offense.
With regards-
Yes, same as that of the provision. They cannot proceed to the other provision of the law.
Here in this case, Arms Act is also there.
Yes, others.
They cannot proceed further.
Yes, yes, but
If the UAP goes
yes, ma'am.
for non-compliance of the 45.
Is arising out of UAP, ma'am.
No, initially it was only under IPC, and then the Arms Act was also there. Okay, the UAP was added later on only, I think. Arms Act is also there.
Yes,
But
sanction is also, for arms act sanction is there, my lord.
sanction is there.
Yes.
Only for
Yes, yes,
UAP.
your lordship, after my brother,
Okay,
I will come to
okay.
it.
This is madam. Primarily, the ground is UAP, ma'am, because these all evidence connected to UAP only, ma'am. The other project is ancillary, ma'am. Main is UAP, madam. Because of UAP, this all the section attracted, madam. Once UAP got, madam, this other thing will not happen. Madam, in this regard, madam, this is related to Tata, and the provision of taking cognizance was also similar, madam. In the not by Gauri in the state of versus state of the draft. The Honorable Supreme Court, madam. If in case if there is no valid sanction under the special act, then that trial court, madam, who's proceeding with the special act cannot also take proceeding or take cognizance with respect to the other court, because it is connected, it's not segregated. If it's not segregated, now. There are 8, madam, that's it. Taking cognizance is the act which the designated court has to perform, and granting sanction is an act which sanctioning authority has to perform. Later is conditioned precedent by the former. sanction contemplated in subsection is the permission to prosecute a particular
You are reading para?
para
Okay, 8. Yes. Yes.
The contemplated subsection is the permission to prosecute a particular person for the offense under TADA. We must bear in mind that sanction is not granted to the designated court to take cognizance of the offense, but it is granted to the prosecuting agency to approach the court concerned for enabling to take cognizance of the offense and to proceed to the trial against the person arraigned in the report. Thus, when sanction is sine qua non for the enabling prosecuting agency to approach the court in order to enable the court to take cognizance of the offense under TADA as disclosed in the report. The corollary is that if there was no valid sanction, designated court get no jurisdiction to try a case against any person mentioned in the report, as the court is prohibited from taking cognizance of the offense without such sanction. If the designated court is taken cognizance of the offense without valid sanction, such action is without jurisdiction, and any proceeding adopted there, it will be without jurisdiction. There are 18 months. It is obvious that power of designated court to charge the accused with any offense under TADA offense can be exercised only a trial conducted for offense under TADA. When trial for offense under TADA could not have been held by the designated court for want of valid sanction, invested in section 28(2) of 2, sequence is that no valid trial could have been held by that court into any offense under Arms Act also.
But here is it. Okay. Carry
In
on.
this case, when Arms Act was also there, and TADA is
And then the prosecution section of the
yes,
Arms Act.
similar to the present case, man. The TADA and the other section was. Therefore, it says, man, therefore, no conviction under section 25 of the Arms Act is possible or the material connected by the designated court in the present case. In view of above legal position, we have to record an order of acquittal. Therefore, we set aside that conviction. This is what. And when this ultimately matter to have a jurisdiction is barred on the statute matter. The trial court cannot take cognizance and they cannot proceed with the other section connected to the UAPA Act also. This is my respectful submission. Therefore, my respectful submission, madam, this criminal petition is maintainable man under 582 in against the 480 of the CRPC. Therefore, and since the manner in which the charge sheet investigation charge sheet has been found, it is illegal and no cognizance, no prosecuting will attend upon taking pursuant to the charge because it's illegal. Therefore, my respectful submission, madam, irreturnable that the proceeding of the trial court will be made.
Yes.
May I please, Your Lordship? Your Lordship, before I start, Your Lordship, I would like to apprise this court that the FIR informant is the official informant, police official only, and I have been instructed to appear on his behalf also. So now, Your Lordship, on the last part, Your Lordship, I will come on the maintainability. First, I will initiate with the charge sheet, Your Lordship. Since they have stated that the charge sheet is illegal, my lord. Your Lordship, I didn't find anything here in the UAPA Act speak about charge sheet. Charge sheet is dealt by BNS as or corresponding CRPC, my lord. And requirement is under the BNSS is provided under section, my lord, 193, my lord. 193 of the BNSS provide that corresponding to 173. Is speak about charge sheet.
Yes.
What things are to be there, what material are to be there for filing the charge sheet. And again, at the same time, it is also well stated, Your Lordship. Charge sheet is the culmination of, Your Lordship, investigation. So, if investigation is not correctly done, it will be either illegal or defect. And again, it is well stated that illegal or defect investigation, however serious, do not have bearing on the competency or the procedure for the purpose of taking cognizance or trial, my lord. Now, Your Lordship, in support of my submission, my Lord, I will rely this judgment of the Honorable Apex Court, Your Lordship. It is long time it is settled, Your Lordship. It's no more res integra, my Lord. Your Lordship, para 9 on charge sheet, Your Lordship, because, Your Lordship, I will come to the judgment of the later part also, Your Lordship, where it says what cannot be done directly cannot be done indirectly also. So now, Your Lordship, may kindly come to para 9. Actually, Your Lordship, the charge sheet got nothing to do with this case, Your Lordship. Why, my Lord? When charge sheet is filed, Your Lordship, what is the procedure? If magistrate found that there are sufficient material to take cognizance, then the charge sheet will be a complete charge sheet. And the UAPA Act, it only speaks that cognizance of the court. And it says the court shall not take cognizance without this sanction. But it doesn't say charge sheet without accompanying sanction. Charge sheet is not there, Your Lordship. Charge sheet, once investigation is completed, it is mandated by the statute to file the charge sheet. For purpose of cognizance, sanction must be there. Just like PC also, my Lord, the section 19, I will come to that. Now, Your Lordship, I will come whether the defective or the illegal investigation. Illegal investigation will definitely make the charge sheet illegal, Your Lordship. So whether that can be a ground for quashing of the charge sheet? No. Now, Your Lordship, may kindly come to para 9. The question then required to be considered whether and to what extent the trial which follows such investigation is vitiated. Now, trial follows cognizance, and cognizance is preceded by investigation. This is undoubtedly the basic scheme of the court in respect of cognizable cases, but it does not necessarily follow that the invalid investigation nullifies the cognizance or trial based thereon. Here, we are not concerned with the effect of the breach of a mandatory provision regulating the competence or procedure of the court as regard cognizance or trial. It is only with reference to such a breach that the question as to whether it constitutes an illegality, vitiating the proceeding, or a merely irregularity arise. Now, here, Your Lordship, this is the important part. A defective or illegality in investigation, however serious, has no direct bearing on the competence or the procedure relating to cognizance or trial. No doubt, a police report which results from an investigation is provided in section 190 of the Code of Criminal Procedure as material on which cognizance is taken, but it cannot be maintained that a valid and legal police report is the foundation of the jurisdiction of the court to take cognizance. Section 190 of the Code of Criminal Procedure is one out of a group of sections under the head requisite for initiating of proceedings. The length with that of other sections of the group under the same heading, that is section 193 and 195 to 199. These latter sections regulate the competence of the court and bar its jurisdiction in certain cases, excepting in compliance therein. But section 190 does not, Your Lordship. While no doubt in one sense, clause A, B, and C of 191 are conditions required for taking cognizance, it is not possible to say that cognizance on a valid police report is prohibited and is thereof a nullity. Such an invalid report may still fall either under clause A or B of the section 191. Whether it is one or the other, we need not force to consider. And in any case, cognizance so taken is only in the nature of error in proceeding antecedent to the trial. The situation AK section 537 of the Code of Criminal Procedure, which is followed as time attracted, subject to the provision herein before, contained to finding sentence or order passed by a court of competent jurisdiction shall be reversed or altered on appeal or revision on account of any error, omission, or irregularity in the complaint, summon, warrant, charge, proclamation, order, judgment, or other proceeding before or during trial, or in any inquiry or other proceeding under this code, unless such error, omission, or irregularity has in fact occasioned a failure of justice. If therefore cognizance is, if taken on a police report vitiated by the breach of mandatory provision relating to investigation, there can be no doubt that the result of trial which follow it cannot be set aside unless the illegality in the investigation can be shown to have brought about a miscarriage of justice. That an illegality committed in the course of investigation does not affect the competence and the jurisdiction of the court for trial is well settled as appear from the cases in Prabhu versus Emperor and Lambudar Jutsi versus King. This no doubt relates there is no doubt related to the illegality of arrest in course of investigation, while we are concerned in the present case with the illegality with reference to the machinery for the collection of the evidence. This distinction may have a bearing on the question of prejudice or miscarriage of justice, but both the case clearly show that invalidity of the investigation has no relation to the competency of the court. We are therefore clearly also of the opinion that where the cognizance of the case has in fact been taken and the case has proceeded to the termination, the invalidity of the precedent investigation does not vitiate the result unless miscarriage of justice has been caused thereby. So, Your Lordship, so far as the charge sheet is concerned, my Lord, there, Your Lordship, bring in between the charge sheet only to make their application maintainable. Now, Your Lordship, second part, I will come on section 45 of UAPA Act, my Lord. The judgment whichever has been relied by my learned senior brother, my Lord, all the judgments are based on the sanction which has not been accorded by the properly or not accorded by the concern of proper authority, Your Lordship. Here in this case, there is no any sanction. And we have to understand, Your Lordship, the time frame which has been given, the mandatory, it's a mandatory, no doubt, Your Lordship, 7 days respectively, and it should be in total 14 days. But when it will be reckoned, it won't be reckoned from the day when investigation is complete or charge sheet is filed. It will be reckoned from the day when the records were submitted to the authority, my Lord. That part is still premature, my Lord, to argue at this stage. I will show Your Lordship my humble understanding of this provision. My Lord, may kindly come to Rule 3, my Lord. Here in this case, Your Lordship, this is not a case where sanction has been accorded. And no application as on that, to my understanding, to my instruction, is there, Your Lordship. Here we have to understand section 3 and 4, my Lord, of UAPA Recommendation and Sanction Prosecution Rule 2008, my Lord. May I read Rule 3, my Lord.
Rule 3 of unlawful activity.
Your Lordship, this unlawful activity prevention, recommendation and sanction of prosecution Rule 2008.
Yes.
3, my Lord. The authority shall. Now, Your Lordship, the authority is independent. Authority is not referring to the police. Shall, under subsection 2 of 45 of the Act, make its report containing the recommendation of the central government or, as case may be, the state government within 7 working days. Now, this is important. Of the receipt of the evidence gathered by the investigation officer. It is only after the application, my Lord. The clock will tick. Not after completion of the investigation, my Lord. Past record has to be produced before the authority, my Lord. And then, Your Lordship, the second part is section Rule 4, my Lord. The central government or, now Your Lordship, after receipt of the record, authority will make a recommendation to the central government or the state government, as case may be. Now, on receipt of that, what state government or the central government will do, that is provided in Rule 4, my Lord. The central government or, as the case may be, the state government shall, under subsection 2 of section 45 of the Act, take a decision regarding sanction for prosecution within 7 working days after receipt recommendation of the authority, my Lord. There is nothing to do with the filing of the charge sheet, my Lord. The time will be reckoned as in when the authority received the record from the investigation agency, my Lord. So now in this case, admittedly, there is no sanction. The only question before this court is whether the cognizance taken by the concerned court against only confined to UAPA, because Your Lordship, for other section again I will come, is with jurisdiction or without jurisdiction. I said, Your Lordship, yes, without jurisdiction, he has taken cognizance. Now, for the other section, my learned brother, senior brother has says it will go along with the main section, UAPA. No. All the sections has to be all the sections are operating in their respective field, my Lord. The offense has to be looked into independently, Your Lordship. UAPA, for prosecuting the offense under UAPA, sanction is required. There is no any sanction required for prosecuting for offenses under IPC. For Arms Act is there, for which sanction has been accorded. Now, I will pause for the moment here, Your Lordship. Now, what will be the recourse at this moment? They ought to have challenged the cognizance order because cognizance is bad in law. And cognizance order, Your Lordship, if cognizance is challenged, then cognizance, the maintainability part. The second part comes, if cognizance is interfered, what will be second steps? Now, the second step would be, Your Lordship, the learned special court will not have the jurisdiction to proceed with the other offences because he is not clothed with the power of special court. So, all the record has to be sent back to the CJM, Chief Judicial Magistrate, my lord, for trial of the other offences. Why I am saying so? Why, Your Lordship? Because regarding sanction part, Your Lordship will also aware of the PC Act, my lord, Section 19, which is a paramount importance for taking cognizance by the magistrate to prosecute a public servant. Or PC Act. 197 is something different. It can be considered even after taking cognizance during the trial also. So now, Your Lordship, I would like to rely on judgment on that, my lord. Wherein, Your Lordship, the Honorable Supreme Court, it's reported in 2023 SCC Online SC 952, my lord. Here, Your Lordship, here in this case, there was no any prosecution sanction to prosecute for PC Act, my lord. But for other offences, Your Lordship, 197 would be, whether it would be required or not, that has to be considered on the later part. And on that aspect, the Supreme Court has not interfered by the order passed by the High Court so far as PC Act is concerned. But Honorable Supreme Court has directed that the court can proceed with the other offences. Because for that, the sanction, procedure of sanction is totally different. Now, Your Lordship, may kindly come to para 55 onward, my lord. I will start from para 55, my lord. Sanction contemplated under Section 197 of the CRPC concerns a public servant who is accused of any offense alleged to have been committed by him while acting or purporting to act in discharge of his official duty, whereas the offense contemplated in the PC Act 1988 are those which cannot be treated as act either directly or even purportedly done in discharge of his official duty. The offense under IPC and offenses under the PC Act are different and distinct. What is important to consider is whether the offenses for one reason or the other punishable under the IPC are also required to be approved in relation to the offenses punishable under PC Act 1988. Yeah, this is a good question, my lord. That whether for the other offenses also the sanction is required for UAPA, the same. Now, Your Lordship, it is important to draw distinction between an order of sanction required for prosecuting a person for commission of offense under IPC and an order of sanction required for commission of offense under Section PC Act 1988. Para 58. In Kalichan Mahapatra, the state of Odisha, the sanction contemplated in Section 197 of the Code concerned a public servant who is accused of any offense alleged to have been committed by him while acting or purporting to act in discharge of his official duty, whereas the offenses contemplated in the PC Act are those which cannot be treated as act either directly or even purportedly done in discharge of his official duty. Parliament must have desire to maintain the distinction, and hence the wording in the corresponding provision in the former PC Act was materially imported in the new PC Act without any change in spite of the change made in 197 of the Code. Para 59. In Lalu Prasad alias Lalu Prasad Yadav versus State of Bihar, the Supreme Honorable Effects Court observed as under. It may be noted that Section 197 of the CRPC and Section 19 of the PC Act operate in conceptually different field. In cases covered under the Act, in respect public servant, the sanction is of automatic nature, and thus factual effects are of little and no consequences. Conversely, in a case relatable to Section 197 of the CRPC, the substrum and the basic features of the case have to be considered to find out whether the alleged act has any nexus with the discharge of duty. Position is not so in case of Section 19 of the Act. Thus, although in the present case, the appellant has been discharged from the offense punishable under PC Act, yet for the IPC, he can be proceeded further in accordance with the law. From the aforesaid, it can be said that there can be no thumb rule that in a prosecution before the court of special court, the previous sanction under Section 19 of PC Act would invariably be the only prerequisite. If the offense on the charge of which the public servant is expected to be put on trial include offenses other than those punishable under PC Act, that is to say that the general law IPC, the court is bound to examine at the time of the cognizance and also, if necessary, at the subsequent stage as the case progress, as to whether there is a necessity of sanction under 197 of the CRPC. There is a material difference between the statutory requirement of 119 of the PC Act on one hand Section 197 of the CRPC on other hand. In the prosecution for the offense exclusively under Section C Act, sanction is mandatory qua the public. In cases under the penal law against the public servant, the necessity or otherwise of sanction under 197 of CRPC depend on the factual aspect. The test in the latter case is the nexus between act of omission and the official duty of the public servant to commit an offense punishable under the law can never be a part of the official duty of a public servant. It is too simplistic an approach to the adopt and to reject the necessity of sanction under Section 197 of the CRPC. On such reasoning, the safe and sure test is to ascertain if the omission or neglect of the commission. Now, Your Lordship, the Paras 60 clarify everything, Your Lordship. Although in the present case, the appellant has been discharged from the offense punishable under PC Act for want of sanction, actually. Here, Your Lordship, sanction was not accorded for PC Act. Yet, for the offense punishable under IPC Act, he can be proceed further in accordance with the law. So now, Your Lordship, in the present case, Your Lordship, he is booked for Section 13. From here, Your Lordship, I'm simply try to, Your Lordship, distinguish both the offenses. If UAP, Your Lordship, for taking cognizance of an offense under UAPA Act, my Lord, no doubt, Your Lordship, the sanction is mandatory, my Lord. But for Arms Act also, Your Lordship, sanction is mandatory under Section 39. If Section 39, the sections provided under 39 is there, for that sanction is there, they are not disputing that. For IPC also, Your Lordship, sanction, there is no any question of sanction. Here in PC Act and 197, Your Lordship, the government servants are protected under PC Act also and under 197 also. But here in this case, the accused is protected under for prosecuting under UAPA Act only, not under BNSS or BNS or Arms Act, my Lord. So even if, Your Lordship, this court interfere the cognizance order, my Lord, the remaining sections, my Lord, Arnet court having the jurisdiction can proceed with the case. And now, Your Lordship, the second part would be, Your Lordship, the maintainability matter. The judgment whichever has been relied by my brother, Your Lordship, in all the cases, the cognizance order was quashed and the subsequent proceeding, my Lord, not the charge sheet, my Lord. For challenging the charge sheet, Your Lordship, if no case is made out, for example, Your Lordship, in order to challenge the criminal proceeding like FIR, Your Lordship, if FIR does not disclose commission of any offense, my Lord, the subsequent development has to be, Your Lordship, put into challenge. Why? Because once FIR goes, if root goes, everything goes, my Lord. They cannot come with, Your Lordship, multiple, Your Lordship, stage-wise, Your Lordship, proceeding. Now, they are partially they say they have challenged the charge sheet. If charge sheet cannot be interfered, then they will come with the cognizance part. That cannot be done, Your Lordship. For cognizance, you have to come with a revision. Your Lordship, we have to understand why revision and why 482, my Lord. Why 528? 528 is always there with the High Court, no doubt, Your Lordship. Even in the, while considering the bail application, court can exercise its inherent power. But, Your Lordship, it is also well settled, Your Lordship, in Sakri Basu, when remedy is there, why you are invoking the exceptional jurisdiction of the court, inherent power. And in, Your Lordship, as Your Lordship is well aware of the Section 397, read with 401 of the revision jurisdiction of this court, the court can call for the record and can analyze the record that the validity of the order, legality of the order, propriety of the order. But in 482, Your Lordship, they have to establish an exceptional case, my Lord. Here is a simple, Your Lordship, the cognizance has been taken without sanction for UAPA Act. And once, Your Lordship, sanction is not there, the special, admittedly, the special court will not have the jurisdiction to act as a special court. So, if sanction is not there, the special court ought to have sent the record to the concerned CGM, my Lord, for proceeding to proceed further with the other offenses, my Lord. They simply, UAP sanction is not there, the UAP, if UAP goes, then other will also go. No, Your Lordship. What about the material, the arms which has been recovered, Your Lordship? If it is quashed, what to do with these arms? Because offense once committed, the crime never dies, my Lord. UAP is there, but other, Your Lordship, these offenses operating in different field are also there, Your Lordship. The accused person should not be left scot-free, my lord, for committing this kind of offense, my lord. And there is a material, your lordship. They are not saying the other sections are not attracted. They are simply challenging the charge sheet because charge sheet is not accompanied by the sanction. Or for investigation also, your lordship, sanction is not required like PC Act 17A. For investigation, police can investigate the matter. And once investigation is complete, it is mandated to file a charge sheet. And only for purpose of taking cognizance, sanction is required. And here in this case, no sanction has been filed. No sanction has been applied for. If it is applied for, then your lordship, I have pointed out the rule 3, my lord. It will be computed from the day when authority received the record. Then from that day, the clock starts. Then the authority will send it to the central government or the state government, recommended it to the central government or the state government for sanction. And on receipt of the same, then again the time will start. That it has to be accorded within 7 days. Now, in this case, nothing such has happened, my lord. The judgment, your lordship, I have the judgment on your UAPA Act, your lordship. Here also it says, regarding the sanction, it has to be raised before the trial court at the earliest stage. But I cannot rely the judgment. Why? Because there is no question of sanction, your lordship. Sanction has not been granted. This is a case without sanction, my lord. So, your lordship, why your lordship, they ought to have challenged the cognizance order, my lord. And if cognizance order come, they are just trying to circumvent the, your lordship, the bar under 397, your lordship. My learned senior brother has rightly pointed out that in some circumstances, your lordship, it can be exercised 482, your lordship, where your lordship, to prevent the miscarriage of justice and for the ends of justice, to prevent abuse of process, no doubt, when the interference of the court is indispensable, the bar under section 397 will not limit the power of the High Court. This is well settled, man. But here in this case, your lordship, what is the difficulty for challenge? They are actually challenging the cognizance order only, my lord. As your lordship, they are also relying the judgment where only cognizance order and framing of charge of this offense have been interfered, not reverse effect on the FIR or the charge sheet, man. So now, so far as your lordship, the interlocutory order is concerned, your lordship, I would also would like to rely few judgments. Because your lordship, once your lordship, once your lordship, this court held that this Planet Special Court has exceeded its jurisdiction by without sanction proceeded, then your lordship, for other offences, there must be a committal order. Even if it is session trialable, there must be a committal order. Without committal order, the session court can cognizance. Yes, to that extent, court can interfere. And judgment, whichever has senior brother has relied, your lordship, he is correct. Yes, that court cannot proceed with the case because the procedure is there. If suppose the special court is acting in a POXO matter, then situation would have been different. In POXO matter, what law says? While trying the POXO case, if other offense also come, then the special court can try the other offenses also. But in this case, my lord,
If it's segregated.
yes, in this case, other offenses are Arms Act and IPC, my lord. For that, your lordship, without committal, because your lordship, admittedly, sanction is not there. So then, your lordship, the cognizance order so far as UAPA is concerned is illegal, my lord. But for the other offenses, he cannot proceed because without committal order, your lordship. Without committal, my lord, the committal section is there where the special court assume its jurisdiction. Without committal, the session court cannot take cognizance of the offense, your lordship, which is provided in 209, your lordship. 193 and corresponding to 213, your lordship. Without committal, the session court cannot take cognizance, my lord. So that things come when it is interfered.
If it goes because of
Sanction.
sanction of the sanction, then it has to go back to
CGM, my lord.
CGM for
Yes.
for proceeding, for the
Yes.
proceeding. For
Yes.
committee. for drawing of the committee of proceeding.
Yes, my lord. This is the procedure, my lord. And your lordship, what I said earlier, your lordship, what cannot be done directly cannot be done indirectly, my lord. No doubt, for ends of justice, your lordship can exercise his power for inherent power. But your lordship, this issue that regarding exercising of inherent power, revision power, for a decade it has been discussed before the Honorable Supreme Court and before the High Courts also, your lordship. Otherwise, your lordship, everyone approaching this court by invoking 528, then other section of the provision of the CRPC will be redundant, your lordship. Your lordship, I will rely this Girish Kumar Suneja matter, your lordship. I'll already refer this. Yes. Your lordship, earlier there was a concept of interlocutory and final order, my lord. Your lordship, AIR 2017 Supreme Court 23620. Girish Kumar Suneja versus CBI, my lord. This is on your lordship regarding interlocutory and final order, my lord. And one more concept is there, intermediate order. Your lordship is well aware that the interlocutory orders are purely and procedure in nature, and which does not affect the right and liability of an individual, your lordship, and is proceeds toward the final adjudication. But final order, your lordship, just like acquittal, my lord, when the proceeding is culminated, conviction, final order. Now, the new concept was come, that was the intermediate order, my lord. That interlocutory order, if reversed, then it will culminate the main proceeding, my lord. That orders are intermediate orders. Since it is not interlocutory, it has to be challenged under revision. Now, your lordship, may kindly come to para 17 first, my lord.
Para 17.
17, your lord, 17. My lord. Here, your lordship, cognizance order was also, your lordship, discussed, your lordship. There are three categories of order that a court can pass: final, intermediate, and interlocutory. There is no doubt that in respect of a final order, a court can exercise its revision jurisdiction. That is in respect of a final order of acquittal or conviction. There is equally no doubt that in respect of an interlocutory order, the court cannot exercise its revisional jurisdiction. As far as the intermediate order is concerned, the court can exercise its revision jurisdiction since it is not an interlocutory order. Now, your lordship, that may be noted, your lordship. In intermediate, revision jurisdiction can be exercised. Now, your lordship, may kindly come to para 24.
Para 24.
24, yes, my lord.
Yes.
Yeah, married, your lord. The second reason why Amarnath AIR so and so is important is that it invokes the principle in context of criminal law that what cannot be done directly cannot be done indirectly. Therefore, when section 397(2) of the CRPC prohibited interference in respect of interlocutory order, section 482 of the CRPC cannot be availed of achieve the same object. In other words, since section 397(2) of the CRPC prohibited interference with interlocutory order, it would not be permissible to resort to 482 of the CRPC to set aside an interlocutory order. This is what this court held. While we fully agree with the view taken by the learned judge that where a revision of the High Court against the order of the subordinate judge is expressively barred under subsection 2 of 397 of 1973 Court, the inherent power contained in section 482 would not be available to defeat the bar contained in section 397(2). Section 482 of the 1973 Code contains the inherent power of the court and does not confer any new power, but preserve the power which the High Court already possessed. A harmonious construction of section 397 and 482 would lead to irresistible conclusion, and where a particular order is expressively barred under 397(2) and cannot be subject to revision by the High Court, then to such a case, the provision of section 482 would not apply. It is well settled that the inherent power of the court can ordinarily be exercised when there is no express provision of the subject matter. Where there is an express provision barring a particular remedy, the court cannot resort to the exercise of inherent power. Now, your lordship may come to para 25. This view was reaffirmed in Madhu Limia, reported in so and so. When the following principles were approved in relation to section 482 of CRPC in context of so and so, the principles are that the power is not to resort to if there is a specific provision in the code. It says if there is a specific provision, your lordship, it should not be resorted. The redress of the grievance of the aggrieved party, that it should be exercised very strongly to prevent abuse of process of any court or otherwise to secure the ends of justice, that it should not be exercised as against the express bar of law engrafted in any other provision of the code. Therefore, it is quite clear that the provision in section 397 of the CRPC will govern section 482 thereof. So we endorse this view, your lordship. Now, your lordship may come to para 27. Our conclusion on this subject is that while the appellant might have entitled not a right to file a revision in the High Court, but the entitlement can be taken away, and in any event, the High Court is under no obligation to entertain a revision petition. Such a petition can be rejected at the threshold. If the High Court is inclined to accept the revision petition, it can do so only against a final order or an intermediate order, namely an order which, if set aside, would result in culmination of the proceeding. Here also in this case, your lordship, if your lordship interfere, then the proceeding under UAPA Act will be culminated, your lordship. As we see it, there appear to be only two such eventualities of a revisable order, and in any case, only one such eventuality is before us. Consequently, the result of para 10 of the order passed by this court in that the entitlement of the appellant to file a revision petition in the High Court is taken away, and thereby the High Court is deprived of exercising its extraordinary discretion power available under 397(28). However, this does not mean that the appellant have no remedy available to paragraph 10 of the order does not prohibit the appellant from approaching this court under Article 136 of the Constitution. Therefore, all that has happened is that the forum for ventilating the grievance of the appellant has shifted from the High Court to the court. It was submitted by one of the learned counsel that this is not good enough for the appellant, since this court is not obliged to give reasons while dismissing such a petition, unlike the High Court, which would necessarily have to give reason if it is rejected a revision petition. In our opinion, the mere fact that this court could not dismiss the petition filed by the appellant under section 136 of the Constitution without giving reason does not necessarily lead to the conclusion that the reason will be given on that some equitable order will be passed. Now, para 29, your lordship. This lead us to another facet of the submission made by the learned counsel that even the avenue of the proceeding under section 482 of CRPC is barred as far as appellant are concerned, as held in Amarnath, and with which conclusion we agree. If an interlocutory order is not revisable due to prohibition contained section 397(2) of CRPC, that cannot be circumvented by resort to section 482 of the CRPC. That can hardly be any serious dispute in this proposition. So now, your lordship, this cannot be circumvented, your lordship. Now, here in this case, your lordship, they have not invoked the revision provision. Here in this case, they have invoked revision provision. Here in this case, your lordship, they have a remedy for revision, but they are invoking 528 just to challenge the this cognizance order, my lord. And in your lordship, revision jurisdiction, your lordship can go through the record also, your lordship. That we have to understand, my lord, because if there is an express provision, expressively delineated by the legislature, that the High Court has a power to call for the record of the trial court and can analyze, your lordship, whether it has been correctly or rightly appreciated or not, whether the learned trial court has exceeded its jurisdiction or not. All that aspect can be considered under 397. So when such remedy is available, your lordship, why there is a requirement of exercising the inherent power which is already with this court, but only in the cases where there is no any express provision to exercise or challenge a particular matter, my lord. And now, your lordship, para 21, your lordship, I will come back to para 21, your lordship. 2-1, my lord, 21. I just missed out, your lordship.
Yes.
The concept of intermediate order was further elucidated in Madhu Limia versus State of Maharashtra by distinguishing a final order and a interlocutory order. This decision says down the principle that intermediate order is one which is interlocutory in nature, but when reversed, it has the effect of terminating the proceeding and thereby resulting in a final order. Two such intermediate order immediately come to mind: an order of taking cognizance of an offense and summoning an accused, an order of framing charge. Expressively, your lordship here mentions Supreme Court. The cognizance order is also an interlocutory order, but it's intermediate nature. Prima facie, this order are interlocutory in nature. But when an order taking cognizance and summon an accused is reversed, it has to be effect of terminating the proceeding against the person, resulting in a final in his or her favor. Similarly, an order framing of charge, if reversed, has the effect of discharge the accused person and result in final order of his or her favor. Therefore, an intermediate order is one which is passed in certain way, the proceeding would terminate, but if passed in another way, the proceeding would continue. So now here expressively Supreme Court in illustration also, your lordship, clearly says the order of taking cognizance is an interlocutory, but it become intermediate when it is reversed. So now when this honorable court interfere the cognizance order so far as UAPA section is concerned, then it will result in discharge of the accused in respect of that offense. So it's an intermediate order, your lordship. So it has to be challenged by way of revision, not by way of 482 or 528, corresponding section of BNS. And your lordship, in para 17 itself, it has Supreme Court has held that what cannot be done directly cannot be done indirectly. And why revision, my lord? Because in revision, the person, the accused, has to approach the court within a time frame, that is 90 days limitation is there, my lord. When the order is passed, within 90 days they have to approach the court. But there is no any limit in 528 or 482, my lord. So in most of the occasion, your lordship, to circumvent that limitation, the accused normally, your lordship, invoke 482. But here, your lordship, para 21 is very clear. Supreme Court has clearly had that order of cognizance is a intermediate order where revision lie.
Yes. So you are representing respondent number 2 also?
Yes, your lordship. I've been in, so because it's a official, your lordship, informant. It was DSP, SDPO, Itanagar, your lordship. So, your lordship, what I'm trying to point it out, your lordship, even if your lordship find that for ends of justice, this case is required to be interfered, your lordship, it can be interfered so only limited to, your lordship, the cognizance taken under UAPA Act. And why the cognizance order has to be interfered entirely? Because without committal order, my lord, the special do not have the power to take cognizance. Otherwise, your lordship, for other offenses, if the special court have the power, then in such case, only this section ought to have been expunged or interfered, your lordship. But for the other offenses, your lordship, then the proper procedure under BNSS has to be appreciated, your lordship. Your lordship may kindly come to why I am saying for interference of the cognizance order, your lordship, but not the charge sheet or the FIR, my lord. FIR, they have no challenge. Charge sheet, only for the maintainability they have said, and it is well established, your lordship, charge sheet is not required to be accompanied by the sanction. Because investigation, your lordship, act of investigation complete when, your lordship, the IO form his opinion to draw report. But it is the statute mandate that charge sheet has to be filed. But for taking cognizance, after filing of the charge sheet, magistrate hardly, your lordship, immediately take cognizance. That stage is the inquiry stage, actually, committal inquiry, my lord. The magistrate ought to have considered whether cognizance or sanction has been filed or not. If sanction is not filed, then he ought to have returned the record. That has not been done in this case, no doubt, your lordship.
So trial court, according to you, could have returned the record.
Yes, Your Lordship. The CGM court, my lord.
Hmm.
Because Your Lordship may kindly before Your Lordship. My lord may kindly come to the provision, my lord, because the other sections which are under which the offence are booked is section 147, 149, 150 of BNS. Read with 13, for 13 cognizance cannot be taken. Section 25(1), 1B, small a, 27(1) of the Arms Act 1959. So now, Your Lordship, for these offences, there must be a committal by the magistrate, my lord, for taking cognizance. If it is session triable, if it is not session triable, the learned magistrate can proceed with the matter. And let the, Your Lordship, the jurisdiction of the
So
matter.
this section 25, 1B, and 27 are tribal by?
Your Lordship, basically this, or if it is triable by the session court, supposedly, my lord, the learned magistrate has to comply with the section 209, Your Lordship. Without committal, my lord may kindly come to the section 213 of the CRPC, my lord.
Two?
213. 213, my lord. Because the, for arm's sake, there is no special court, my lord. 213, my lord.
Yeah.
Except as otherwise expressively provided by the Sanghita.
213?
Oh, BNSS, my lord. 213 BNSS.
Yes.
213 in 213 BNSS 193 of CRPC corresponding section, Your Lordship. I'm sorry. The 213 says, except as otherwise expressively provided by the Sanghita or by any other law for time being enforced, no court of session shall take cognizance of any offence as a court of original jurisdiction unless the case has been committed to it by a magistrate under the Sanghita. That means, Your Lordship, commitment must be there, Your Lordship. Because once UAPA goes for want of sanction, the special court do not have power to try the matter directly without committal.
So, anything else?
Your Lordship, more or less, Your Lordship, I've covered all of the aspects, Your Lordship, regarding the maintainability also, because Your Lordship, they are saying that they are challenging the charge sheet, but charge sheet challenge, Your Lordship, or not accompanied with the sanction. It's not, I think it's a misconception of law, because section 45, Your Lordship, doesn't speak about charge sheet, Your Lordship. Section 45 of the UAPA Act. It only speak about sanction, my lord.
It is that there is no primary facie case under other sections. Other section. Other offense.
I'm saying that since main primary the
Okay,
section
only that, only that.
and that part, my lord,
Only
the
that.
other connected offense could not have also been taken cognizance.
Okay. Yes.
That much, my lord. And Your Lordship, section 45, my lord, we have to understand the stage. First is FIR, then investigation, then completion of investigation, then filing of the charge sheet, then committal inquiry, and then comes cognizance, pre-cognizance stage. This is inquiry stage, committal stage, then cognizance, and then come post-cognizance. then framing of charge, then commencement of trial. So, Your Lordship, so far as investigation part is concerned, there is no any illegality. Even if we assuming there is an illegality, it doesn't debar the learned trial court from taking cognizance or proceed with the trial. That the law I've already submitted, madam. So, my lord, with this, Your Lordship, I propose Your Lordship may dispose of this matter.
Yes, yes.
My lord, I just clarified 2 point, my lord. That my brother has relied some decision with regard to the BCA, man, prevention of corruption case related, man. That was under BCA, my lord. There's no provision for evaluating the evidence material collected by the investigating agency during the course of investigation. That provision is not there. But so far UAP Act is concerned, my lord, there's a provision, my lord, before forwarded to the authority, the competent court, my lord, the whatever material they have collected during the course of investigation, that is to be scrutiny by the independent committee recommended for the government for granting sanction. But that part, madam, that is not done.
That is why that having not done, your prayer is that it should go.
Yes, that is my.
Okay.
So that part, madam, the one thing, madam, that is what I'm the repeatedly the praise my brother has said, that what cannot be done directly, it cannot be done in. Now, when says that before forwarding it to the court of law, madam, the whatever material you have collected, this is to be examined, reviewed by the independent committee. You have not done, and no prosecution sanction obtained. In that view of the matter, when it is not done directly, so by making round that the other part we can do it. When the cognizance itself is prohibited, madam.
No, see. Is there the prosecution sanction for the arms act is there?
Yes,
On
sanction.
record-
Yes,
on record.
prosecution sanction is there, Your Lordship. It is already filed before the learned trial court, my lord.
No, not on this record.
Yes, Your Lordship.
Is
And
it
Your
in the-
Lordship,
is
they
it in the record.
No, Your Lordship, they are not raising this issue, my lord. This issue is not before this court regarding sanction, my lord.
Submitted.
Yes.
It's on record, no.
No, Your Lordship. And Your
Do
Lordship,
we need to call for the record then? If
Now,
you-
we already
Your
said,
Lordship,
madam, just record as-
If your submission is to that, it should survive in respect of the other offense.
and yes, Your Lordship, even for the IPC, Your Lordship, the IPC or BNS section or the IPC section is also there, my lord. And Your Lordship,
I need,
Or-
anywhere in record, has it been reflected that the prosecution sanction
my lord, may
obtained in respect of the arms act?
if Your Lordship allow me, Your Lordship, I would like to make a humble submission, my lord. The section 58 of the Evidence Act, what it says, the fact admitted need not to be proved. They are not, Your Lordship, disputing that, my lord.
No.
They are not disputing that, my lord. That whether there is a sanction or not. If supposedly,
No.
my lord,
Just because since we have submitted only for reference, if the prosecution sanction in respect of the of
Arms
arms
act.
act had been obtained.
my lord, that aspect can be raised before the trial court also, Your Lordship.
Okay.
They can raise this issue before the trial court while taking cognizance. And Your Lordship, I will clarify my brother, Your Lordship. For section 19, section sanction, my lord, it has to be accorded by the appropriate authority by considering the entire record, my lord, even in PC Act, Your Lordship.
For consideration, yes.
Yes, only difference is, Your Lordship.
Of course, that is by the government.
Yes, and that too by the appropriate authority, my lord. My lord has come across many challenges where it has said that appropriate authority has not considered the record. And that too, Your Lordship, all the material basing on which that person is, the official has to be prosecuted, all this material has to be appreciated. Otherwise, it will amounting to bad sanction, my lord. Same is there. The only difference is, Your Lordship, in PC Act, during the pendency also, Your Lordship, it can be cured. But in this, once for sanction, if it is initiated under UAPA Act, Your Lordship, then it is found to be illegal, Your Lordship, then it cannot be corrected, Your Lordship. Only that is the difference. I have the judgment on that, but Your Lordship, here in this case, sanction has not been accorded. If sanction is accorded, then I would have relied this judgment. This is Puleswar Gope, Your Lordship. It specifically deals
Validity of the sanction, but in this case, they are just cannot be examined to that extent.
Yes, exactly. Sanction is not there. For other offense, it can be proceed, but not for UAPA. That's it. Simple as it is.
Okay. I pass over.
Yes. Obliged.
Mr. Itaku, Land Counsel for the petitioner. I also heard plan additional agent for the state and for the respondent number two.
Two also. Yes.
Okay. Okay. I'll pass over.
Okay. Obliged. For item 4, same only. Same.
That is same.
No,
There is
item number 3, my
There-
name may be reflected.
Hmm?
My name may be reflected on item.
Okay.
Same.
And then in item 3, sorry, item 4. Mr. Tulpa. In item 4 also, Mr. Tokum, you are.
Yes, item 4, I am.
also.
Mostly,
And
Oh, sorry.
item number 3, my lord, it should be in my
My-
others.
Hmm?
my-
What, Toku in 3?
yes.
No, in 3, you're also there. 3 also.
No, that is wrongly
It's,
reflected.
it
Next
seems.
page,
Okay, then in item 3, Toku, huh?
Yes,
Tava Toku. And in item 4, Tava Tokum, huh?
yes.
Okay.
Obliged.
First.
Yes, Lordship, as per the earlier directions, complaint is waiting for RBC since 10:30 AM. This is the high card of the complainant. She's on RBC, Lordship.
On last occasion, my lord, the petition was directed to appear through RBC or
Oh,
in
yes,
person.
yes,
She's
okay.
online, my lord.
Online.
Yes, on the-
Victim, my lord.
Complainant plus
Okay.
petitioner number 1.
So just ask her if she has signed the
नाम क्या है?
baby.
हाँ, आपका नाम बेबी नबलम है ना? ओके, आप वो ये एग्रीमेंट आप साइन किया था ना? ओके, ओके, आपको
कोई ऑब्जेक्शन नहीं है? केस डिस्पोज करने से है? ओके, ओके, that is fine.
ओके, यस यस.
So, you have anything, any more?
No, my lord, since they have settled the matter, and my lord, she has personally appeared also through RBC.
She has
So
no
that will
problem.
suffice, your lordship. And they have
Whatever may be, but she has no problem.
Yes, your lordship. Lordship,
And then this is also, of course, arising out of the matrimonial.
yes, it emanated from a matrimonial dispute.
Right.
No doubt the sections are different. My lord, that's what I pointed out on the earlier occasion. Lakshmi Narayan, in Lakshmi Narayan case, section has not been provided. It says marital dispute. Out of marital dispute, many things may come up,
Yeah.
but it shouldn't have the social impact.
Mhm.
So it's even the dispute emanate from marital dispute only. The husband is having an affair with the victim, and now they have settled, and the first wife is accepted her as to be the second wife.
Second wife.
Yes, yes.
So has it been reflected in the agreement?
Yes, agreement is there, your lordship. It's clearly mentioned in the agreement.
First wife.
Lordship, in page number 21, madam.
Agreement.
Agreement, yes, your
Yes.
lordship. It start from 20. The operating part will start from
What is
21.
this? 30, page 30.
Page
This is additional.
22, your lordship. The first party does not have any grievance against second party in relation to the event occur and late duration so and so. The second,
Para two.
para 2 onward, my lord. May I read out, your lordship?
Yes, yes.
The one of the second party so and so, Srimati so and so, has decided to accept and recognize the first party as second wife of her husband, Sri so and so, which is permissible under Nishi customary law. Further, the parties have decided to lead a peaceful life together. That accordingly, the first party has no objection if any competent court exonerate or acquit the second party for so and so. This is the, your lordship, consideration in this case.
Okay, I'll dispose of it.
Yes, your lordship.
Okay.
In the event,
And then
yes, item number 8, 9, 10, and 11.
All will become infructuous.
Infructuous.
in view of this, or
Yes, yes.
it has become, this will become, okay. Hard Mr. Kamal Saxena, item 5, Kamal Saxena, then counsel for the petitioner. Also have Mr. Okay, then additional people for the state. The this who are the parties there? Okay. Informant is 1.
Yes.
Okay. Srimati, sorry, the informant, Srimati Baby petition number 3 is also present. By go online, na? Okay. And her, okay. So I'll dispose of it.
Highly
Obliged, man. My lord, the only thing here to be take into consideration is the additional affidavit they have filed to make respondent number, one of the accused as respondent number.
minor.
She was minor, and an agreement has been entered by the father on her behalf with the victim, and her name is, your lordship.
No, petitioner number?
It is, she will be petitioner number
40 years,
It
34.
should be
No.
in para 5, my lord, Miss Meming Nablam.
She is not,
she is named in FIR,
okay, name the FIR.
Yeah, named in the
but she is
FIR.
minor.
So that was not segregated at the time of filing.
Yeah, because, your lordship, by the time when they have filed this petition, since she was minor, so they have not
Okay,
implemented.
then, but she is not the petitioner here.
No, your lordship, by way of this affidavit,
Okay, let us see, let us see.
Additional affidavit is there.
additional affidavit was filed by the direction of this court. She has also entered, she on her father on behalf of her, since she is minor, enter into agreement with the victim, my lord.
Page number 29.
Agreement.
Yes,
Page
your
number
lordship.
29.
And then,
29.
Page number 29, my lord, will find.
Separately.
Yeah, it's a continuation of the main petition, my lord, because it's an additional affidavit, my lord.
No, this agreement.
Yes, separately, your lordship.
What
Subsequent.
is his name or her name?
Her name is, my lord will find in para 5. Meming Nablam.
Para 5 of?
Yeah, the additional affidavit.
Okay.
Meming Nablam.
Then, quashing. In quashing, her name also should come.
Yes, your lordship. Otherwise, your lordship, the proceeding against her will be continued. So this,
Then the. Okay, let me clear, the party, please, the, just one paragraph, the petitioner number 1 is right name also for understanding, Baby Navam is the informant. The petitioner number 2, Srimati Chachi Navam Lambu. Petitioner number 3, Srimati Tongchi Lambu Flago. Petitioner number 4, Srimati Yani Navam, sorry, Navlam. Is Navlam or Nabam?
Nablam. All are Nablam.
Navlam, not
Yes.
Nabam, Navlam. Dada.
and Chunga Nablam,
And. Her name?
yeah, my lord, Chunga Nablam on behalf of her daughter, accused child in conflict with law.
Child in conflict with law is, her name is?
Meming Nablam.
Meming Nablam.
Where do I find?
Para 5, my lord.
Baby, okay, baby.
Last, bottom.
Baby Navlam.
Yes, yes.
Reference, Baby Navlam.
Meming.
MEMING, my lord. My lord will see in
Sorry, just-
continuation, page 25, my lord. 25.
25.
Continuation of the main petition, my lord. Page
Name-
25.
Okay,
However,
MEMING.
Miming
Navlam. Navlam.
represented by the
Represented
father.
Our father. Name?
Chungma Navlam. Page 28, my lord. Page 28.
Chungma Navlam
Yes, your lord.
are the accused in the airport say EWS case number
88.
88/2025 under section 61 to 122 118 of the NSS 2023. Okay, this will cover that. Okay.
Oblige, my lord. Oblige.
And then this, just a minute, this is item 5. Just a minute,
Item number 8, 9, and 10.
just a minute.
Or
Okay,
9 and
then-
11.
Then just. a
9, 10,
minute,
11.
And then item 9.
BA number
10 and
90.
11, in view of the,
BA number 85.
in view of the order passed today in criminal petition number 148/2025. Not 148, criminal petition number 159. This bail application has become infructuous, okay? This bail application is
In process.
stands,
Yes.
disposed on becoming infructuous, okay?
Oblige.
Yes. Yes.
Yes, Your Lordship, in this case, I was arrested on 30/12/2024, and as of today, it is been 7 months I'm in custody. The section that has been invoked against me is 103, that is for murder, and 238, that is for causing disappearance of evidence, and 239, that is intentional omission to give information. Now, before I submit the merits of the facts, may I please take Your Lordship to the FIR, Your Lordship. The FIR that is in page number 17. One second, Your Lordship.
Okay, your bail was rejected earlier.
Yes, the bail was
You were
rejected.
arrested on which date?
Your Lordship. I filed 3 bail applications, and the last one was rejected on 22/5/2025.
Yes, okay. Where is FIR, you said?
It is page 17, 17.
17?
Yes, yes.
Type copies. Yes.
Subject FIR, dear sir, with due respect, I beg to state that one of our employee from R&T Power named Janmoni Das, housekeeping has been missing morning. We tried to contact her multiple times during office hours from 9:20 a.m. to 4:05 p.m. dated 27/12/2024, but her number is not stable. Hence, around 6 p.m., we are informed that the missing person, that is Janmoni Das from police station Dongbuk, is no more, and ask all the employees to cooperate while investigation. Therefore, you are requested to take appropriate action as per law by registering a criminal case. This is the FIR. Now, the facts in this case, Your Lordship, is that the deceased victim, that John Mani Das, there are 2 accused. I am for the accused Rahul Amin, and the other prime accused is Mofizul Haq. So the deceased victim, John Mani Das, and the other accused, Mofizul Haq, they were having affairs. Then on 26/12/2023.
There are 2 accused in the.
Yes.
Okay.
The Mofizul Haq is
One
a
is-
Mofizul Haq. And I am Rahul Amin, the co-accused. I am Rahul Amin, or Rahul Amin, the co-accused.
Rahul?
Amin.
Okay, just a minute. Let us know what is the status of the case.
It is in the stage of evidence.
Evidence.
Yes, the last hearing.
Charge is filed against only those two accused.
Yes, only two.
Who is the main accused?
The Mopizul Haq.
And you are
I'm the co-accused.
co-accused.
Yes.
Charge frame under what offense? For offense? What offense?
103. 103, that is murder.
103 is equivalent to 302.
103, one is murder, you see.
Okay.
And other is 238.
What is 238?
That is for quashing.
DNS.
Yeah, DNS.
What is 238?
Quashing disappearance of evidence.
Okay, 211.
And the third one is 239, that is intentional omission to give information. Intentional omission to give information. Omission,
Okay.
that is the last section.
Okay, both concealment. Okay.
Yes. So the basic ground on which I'm filing this bail application is, even if the whole prosecution story is believed to be true, the section 103 murder and 239 causing this appearance of evidence is not attracted against me at all.
Against?
Not attracted in my case.
Not against,
Not
attracted against you.
Yes. Even if it is taken into consideration the whole prosecution story as true.
Whether you said that evidence, the last stage of evidence.
The
evidence stage. Any evidence recorded?
The evidence of 3 people have been recorded.
Okay. What are their statements? Nothing is there.
Nothing is there. You know, see, if we look at the charge sheet, then it will make things.
Now, why don't you apply bail before then?
I applied bail also. I applied bail before.
That was also rejected.
Yes.
Must have considered on merit.
Yes.
Then
But
what new ground you have taken here?
the first new ground is that at the time of my last bail application, these 3 witnesses, they are not examined.
You must have made application after the examination of these 3 prosecution witnesses.
No, because yesterday was the one day of the appearance of this case.
No. What I'm saying is you must have made bail application before the trial court after examination of these 3 prosecution witnesses.
No. Before.
And after examination 3 prosecution witnesses, if are they the material witnesses? Are these three prosecution witnesses whom the trial court has already examined?
Yes.
Are they material witnesses according to the?
One is very important witness because he is the takedaar under whom I have been working.
No, otherwise no eyewitnesses.
No eyewitnesses.
Okay, circumstantial evidences.
Yes.
So he had implicated the accused number 1.
Yes.
And not to you.
No.
And after that, why don't you make any other witnesses according to you that who has gave police statement against you? Any other?
No statement against.
Then in that case, why don't you apply before the trial court?
Because you see, the trial court has rejected my bail application.
No, earlier.
Yes.
You have not filed bail application, moved bail application after recording of these evidences.
Yes, you must.
The trial court must have thought that these are the material evidences and their recording would be necessary. And now since after examination, after their evidence, if you think that there is nothing and rest are not material witnesses against you, then why don't you make an application before the trial court?
The trial court has refused to give me, relying on a decision by this honorable court.
No, that is what I am saying. So if the trial court has refused, trial court would be the best person to give bail or not to give.
No, it is
considered.
It is a trial court who has advised me to approach the High Court because there is one judgment of this our honorable High Court wherein it is said that the bail should not be granted once the trial commences. So relying on the judgment, the trial court has refused and advised me to approach the High Court.
Now, how do you prove? Then what is the ground that against this and against that the bail should not be granted when the trial commenced?
Because
what is your submission on that then?
I am implicated only because I was present on the day of the occurrence when that lady came.
That is why, see, how many witnesses are total? How many witnesses?
Total there will be around 16 witnesses.
16.
Yes.
Now only 3 have.
Only 3 has been examined. And moreover, you know, if the FSL report, the forensic science report, when that is awaited. So all these facts were also raised before the trial court, but the trial court relying on the.
Now in the murder case, how do we interfere with under the circumstances when the trial court has rejected your bail?
Your Lordship, kindly have a look at the charge sheet, Your Lordship. Your Lordship is very clear.
There is a charge sheet is being perused and then it is under trial. by the trial court only. They are the best person who would be knowing whether to give bail or not under the present circumstances in the case.
Even regarding the charge sheet also, all the facts are,
Now, that is why the trial court would be the best person to examine, to know that, and then why you have come here before this court.
because
When the trial has already begun and they have already rejected your bail
Your Lordship,
after consideration on merit.
if we look at the bail rejection order, Your Lordship, my last
Now,
bail-
see, if the trial court decided the trial has already begun and there is a material and that therefore your bail is rejected, then how do we interfere with?
Your Lordship, because the trial court is rejected not merely on merit, it is also rejected on the ground also because of this High Court order, wherein it has been held that one the trial
Then
case is
this high court order is
but Your
high
Lordship,
court after passing order not to grant bail.
yes,
Then how do this high court again violate his own
yes,
order?
because Your Lordship, my case is different because in that order, it's only for those cases where prima facie the evidence is very strong.
That is why I'm saying that if the trial court has found prima facie case against you, then how do we interfere when he knows the best?
According to trial court, Your Lordship, but that is not that is not so in my case, Your Lordship. Because Your Lordship, I have been implicated only because I was present on the day and only because I paid.
So that has been examined, you see, that will be examined by the trial court only. That you have to prove there that I was only, you are present or not? Oh, what is your submission? You were present.
I was present on the day when that lady came to meet the.
See, and these things, whatever your case, you have to present it before the trial court only. What I'm saying.
That has been presented, but now since those materials were not considered.
Now, if you have not presented properly and if that was not considered, how do you expect this court to examine that?
Your Lordship, kindly have a look at my the charge sheet, Your Lordship. Kindly have a look at the charge sheet and
see charge sheet. I can look at the charge sheet, but then you see charge sheet have been already perused and time and again by the trial court. That is what the trial court has rejected your bail. That is what I am saying, trying to convince you.
that is not the only
That the
case.
trial court is the best person to consider your bail, and that has rejected because the trial is going on. How do we interfere?
Your Lordship,
Unless you have shown extremely the extraordinary point entitling you the bail.
yes, Your Lordship, because my case, Your Lordship, this is a very good case to grant bail. In fact, this is a very good case to grant bail.
And when the trial is on, how do we appreciate the evidence? In the high
Yes, Your Lordship. Please kindly make me allow me to give a detailed submission. Perhaps I have to clarify myself what I'm trying to project.
Yes.
So, if we look at the charge sheet, Your Lordship. This is page number 33.
See, when there is already evidence recorded, how do we go back to the charge sheet now? You say that evidence already recorded.
Your Lordship, that the trial court has not failed to appreciate that I was not involved in the case. Even the same thing is repeated in the charge sheet also, Your Lordship. That is not appreciated by the trial court.
When last your bail was rejected?
It is on 22/5/2025. That is on page number.
The order, have you annexed? Where?
Yes, I have an ex. There is page number 25, Your Lordship. The last,
Page?
page 25.
Yes.
So the relevant portion is para 5, that is on page 5, Your Lordship.
Oh,
page
this is rape, murder, docility, so many things.
Page 26, Your Lordship. Page 26, the relevant portion that has been relied by the trial court. Para 5, page number 26. I have heard both the London councils and also perused the case records and found that there is a serious allegation against the accused persons. And since the case is written into charge sheet and trial is already commenced, Honorable Guwahati High Court, while issuing notice to the accused person who was granted bail by this court after became stand hostile, by order dated so and so, passed in the sumo to criminal petition number so and so, in its para number 39 and 40, put reliance on the Honorable Supreme Court order passed in the case of X versus State of Punjab, decided on 27/24, quoted in 2024 crimes so and so, wherein the Honorable Supreme Court has held that in serious offenses like rape, murder, dacoity, once the trial commences and the prosecution starts examining its witnesses, the court, be it the trial court or the high court, should be loath in entertaining the bail application of an accused case. Your Lordship, this only says it should be loath. It doesn't totally bar the infant bail, Your Lordship. So relying on this paragraph, the trial court has refused my bail, Your Lordship. Whereas, if we look at the facts of the case, Your Lordship,
See, made an observation that there is a serious allegation against the accused.
now Your Lordship, my submission, Your Lordship. Serious allegation is one thing, and serious prima facie is different thing, Your Lordship. But in my case, there is no prima facie material against me, Your Lordship. This is why, Your Lordship, I'm praying again and again to kindly have a look at the charges and into the evidence. Perhaps, Your Lordship, if I give a detailed submission, Your Lordship would kindly perhaps appreciate my case.
No, there is a serious allegation against you.
That is, but
Trial began and trial is on, and then
because Your Lordship, if this case is to be relied, the case which has been read by the trial court,
we can only direct or we can only express that the trial be expedited. Trial be expedited because the court has clearly observed there is a prima facie case material against you, serious allegation against you, and then have to prove that serious allegation. And then if you have any, you have to defend it properly. Now, when the trial is
now Your Lordship, the Honorable the trial court has prepared on the case of this.
now, if we release and anything happens for any reason, if it doesn't appear, that will prolong. That will be that will amount to interference in the trial of the case. So this is serious allegation against you. Yes.
Lordship, here, Lordship, as per the case, this charge sheet, Lordship, charge sheet, Lordship, as per in the charge sheet, Lordship, the accused, Lordship, as per the investigation, Lordship, it is revealed that the page, Lordship, this para second, Lordship, that the accused has not committed, but it is fairly submitting, Lordship, I am accepting has not committed murder, had aided him the commission of crime, Lordship.
Where do
In the page, para second, Lordship, page 33. May I, Lordship?
just
Page 33.
yes.
The involvement of alleged accused Rahul Amin, which is the
What is the name of the present accused?
Rahul Amin, Lordship.
Rahul Amin.
Yes, Lordship, has been thoroughly investigated, and it has been revealed that Sri Rahul Amin has not committed murder or nor has aided him in the commission of crime. The alleged accused Muzaful Haq has also stated in the statement that Rahul Amin is not involved in the murder of the deceased, but he alleged that he has helped him bury the dead body into the ground.
See.
Yes, Lordship. That is yes, Lordship. That is disappearance of the evidence.
How long you have been, you said?
7 months.
7 months. The punishment for this 201, 211. What is this? Earlier 211. For concealment of the dead body. What is the punishment?
Lordship, that is
see involved.
It's 7 years. But my submission, Your Lordship, the maximum that can be attacked is 239. That is for omission to give information.
Lordship, 239, Lordship, it is they only attack because and the prior to the arrest, Lordship, he is not revealing that fact to the before the investigation officer. That's why 239 they have charged, Lordship. Lordship, accused lordship, he might not have murdered that lady, but as per the section 238 lordship, wherein the causing a disappearance of the evidence lordship, as per the statement of the lordship, this other accused lordship, it is revealed that lordship he helped him to bury the dead body in the ground. So that 238 is attracted lordship.
Just let us see in the evidence so far recorded, whether anywhere, any of the prosecution witnesses has took the name of the present accused, Rahul Amin. Where is that?
That is,
Have you annexed
Statement
evidence?
of the.
No.
yes, there is the.
You have annexed the evidence also?
Yes, page 85. 86.
86 is the PW2 lordship.
Just a minute.
This is a PW2 lordship. This is a eyewitness lordship.
PW1 is, that is,
It's a witness lordship,
so
one of
he
the
has not given
witness.
anything, he must relevant information. But the PW2, the Khairul Islam, he is the contractor.
No, who is the informant?
Informant is a lady lordship. One, do you?
Whether the informant has been examined?
No, lordship, because lordship, only 2 PWs has been examined lordship, and
Whether
rest
the informant has been examined?
not yet lordship. His her
Informant should have
statement
been the
is
first
not yet.
person to be examined.
Because the informant is just some other person who was the employer of that lady.
Okay,
So
But the-
she has nothing to do with this case.
the informant is,
Do you mean one lady named Do you mean? And she is,
okay, he did not, or
Yes,
the
yes.
informant did not see.
yes, when this is
On the basis of the information, the informant has filed FIR.
yes, so this is
And
because-
who gave information to the informant?
Because lordship, informer was the employer lordship under
No,
her,
no,
he
no.
employs.
Who gave on the basis of whose information the informant has filed FIR?
Lordship, actually, since morning lordship, he was missing lordship. So missing report, they have lordship actually.
No, no.
was lordship.
So who gave information to the informant?
That's why lordship, because he was the employer lordship, because he used to employ it to her
I
house. But
understand. What is the name of the person who informed
Lost-
this?
to the investigation
employer?
officer, to the investigation officer, FIR who lost lordship.
FIR lodged by the informant.
Yes, lordship.
Who lodged FIR is the informant. Who gave information to this informant about the missing of the deceased?
Lordship, actually,
if the deceased victim, she was working under the employment in their company.
Hmm?
So the deceased victim, she was working
No,
under.
no.
Lordship, as per Lordship here, Lordship, the FIR is received from the Miss Tuyumina because Lordship tried to contact her multiple times during office hour from 9:20 to 4 p.m. dated 27/12/24, but her number was not reachable. Around 6 p.m. they have been informed about a missing person that she is no more and asked all the employees to file investigation. It was Lordship when he. But again, lordship, at 6 p.m. lordship, he was informed by the lordship.
Okay. Who is
Station
this
lordship.
Khairul Islam?
Khairul Islam, you will see this,
Who is PW1? Where is PW1's deposition?
that is in page number 84.
Okay,
No,
Jahidul.
he is not much related to the case.
Hmm?
PW1 is not much related to the case. But the PW2.
One is not much related.
No, because he is not.
Has it, whether he has taken name of the present accused?
No.
The bail is for Rahul Amin.
Yes.
Just to work together. Okay, PW2 has given some
Yes, Your Lordship.
any incriminating material against the accused?
Lordship, some more witnesses need to be, Lordship, recorded their statement. After that, only, Lordship, we can come to the conclusion that accused person is involved or not, Lordship.
Why you have received this record? Okay, you need to peruse the record and pass order. Okay, what we'll do, we'll record you have received.
Yes, Lordship.
Mr. Raj.
Your Lordship, kindly, I'd like to submit one case citation, Your Lordship. I'd like to submit one citation, Your Lordship.
Okay,
Because
Mr.
K. Taja.
K. Raja, counsel for the petitioner. Also had Ms. Malhage, Direct Relation PP. So the trial court record has been received. List this matter again on Monday. Okay. We need to peruse the record. Okay. The time is going and there are other matters also. I need to peruse the record. And if you have any, what is that?
That's citation, Your Lordship.
Citation is regarding what?
Where it says that there is no prima facie material is there.
So that is why we need to see
Yes,
if there is, if really there is no prima facie case against you. But then you admittedly you were present at the time of concealing the dead body of the deceased.
Your Lordship,
So
can
then
it
you
be
are
on, can it be on Tuesday, the 5th?
Tuesday?
Yes.
Okay, Tuesday.
Like-
Okay.
Yeah, Lordship.
Yes.
Lordship, here the applicant is the brother-in-law of the alleged accused, who was arrested in connection to Itanagar PS case number 97 of 25. Yesterday, Lordship, the updated CD was called by this honorable court.
Yes, sir, we have received the case diary. Earlier, the complete CD was not received, so day before yesterday matter was listed. Today, I have received the case diary, Your Lordship.
Okay.
The statements are also there.
What is the offense alleged against the accused?
Lordship, the section they have given is
Robbery.
329, 309, that is trespass, and 329
Yes.
for rob.
329.
Yes, Lordship.
What is 329? 329 is equivalent to
329
corresponding
section.
329 is
IPC.
criminal trespass, Lordship. Bailable offense.
3096 is non-bailable, it's robbery.
329 is bailable, Lordship.
Bailable.
Yes, no. 309 is non-bailable, Lordship.
What is 309?
It's a robbery, Lordship.
309 is corresponding section is
309
for 3
subsection 6.
PNA. What is PNA?
.309 corresponding section is, Your Lordship, 393. 309 subsection 6. Punishment for robbery.
390.
309. 309.
390 is corresponding is 309. Robbery.
Robbery, yes, Your Lordship. Robbery when theft is robbery when punishment for 392. 392 IPC.
Punishment.
Punishment for robbery.
Okay, what is the maximum, minimum?
Your Lordship, extend to 10 and life or life. Extend to 10 or
The
life.
minimum prescribed, no.
Minimum is not there, life.
Okay, what is 3? 3,
3 is
5?
common intention, my lord. Common
Common
intention.
intention.
Oh, 34.
Yes.
Okay, so.
So far as your Lordship, robbery is concerned,
Hmm.
nothing such, your Lordship, as far as they have gone through the CCTV record also. They have not found any firearm pointing on the victim, your Lordship.
That allegation is also there.
Yes, your Lordship. The
allegation
allegation is there, but it has been as per the CCTV record, your Lordship, there was no firearm was used, and even your Lordship, nothing is there to show that the chain.
Whether in the allegation there is a use of firearms.
Lordship, the page 13 is the FIR. FIR, he has given, he has alleged. But during this, nothing such. Page 13, Lordship, annexure 1 is the FIR. May I read, Lordship?
Page 13.
Yes, Lordship.
Yes.
To the officer in charge, Itanagar Police Station,
Okay.
subject immediate action request against assault and theft by miscreant
Come to the body
or
of the
news one today. Respected sir, I Sri so and so, CEO of cum editor in chief of News Today Group. Today's group stroke our TV. I am writing this letter with deep anguish and concern to bring your notice a grave and violent incident that had occurred at our office premises today. A group of miscreants led by so chairman of an ex-MLA of Bombing forcefully entered our office and physically assaulted me, causing multiple injury all over my body. The attack was brutal and carried out with clear intent to cause grievous harm, amounting to attempt to murder. Further, so and so pointed a pistol to my head. This is pointed to my head and forced me to write apologies. The attacker also looted the following items from our office and my person: one office laptop, one CC camera DVR, damaged CC camera unit, one gold chain, approximate so and so. The reason for this violent and unlawful attack seems to be stemmed from the fact that our news channel had posted a news report about so and so arrested by the Itanagar police on so and so. The nature of the assault and targeted looting clearly demonstrate a premeditated act with criminal intent against a media professional, which is not only shocking but also a direct attempt on freedom of press in our democratic country. I therefore request your esteem of this too. So this is the FIR, Lordship. In FIR, Lordship is given.
So I need to go through the record. We'll fix it on Monday. This also.
Lordship, here
you have entire.
Yes,
Have you gone through? Have you gone through?
yes, your Lordship. Here, your Lordship, no firearm was recovered.
Okay, but that is not a register also under Arms Act.
Yes, Arms Act is not there, but
Not registered.
so far as his allegation is concerned, my lord.
Hmm.
And regarding snatching the gold chain, that is also not there, your Lordship. And the one DVR, what he has stated, that was recovered from the accused person, and according to the 180 statement of the co-accused, it has been stated that, your Lordship, that DVR is the old DVR which has been given to the accused himself, given by the victim himself to the accused.
When? After the incident?
On the time of incident.
Okay.
That is
That we do not know.
yes. That is only there, your Lordship. And regarding assaulting, your Lordship, assault part is also, but assault section.
How
is-
many accused are there?
Only one is approaching this court for.
Lordship, there were two accused.
How many were arrested?
Two were arrested, Lordship. One has already been granted bail by the London Session Judge. And today is, Lordship, it's almost 36 days today if you counted from the date of his arrest.
I need to peruse the record.
Okay, your Lordship.
So on Monday.
Okay.
Lordship,
Okay.
Your Lordship, see the.
Lordship, may kindly appreciate.
Keep it.
Okay.
It's a
Original.
scan copy only.
It's original. Your Lordship, we'll scan it and we'll send back the original one. We'll
Yes, send back the original and keep the
Yes,
the
sir.
scan copy.
Yes, sir.
Because this seems to be very small.
Yes, your Lordship.
But then you see, this will encourage.
Lordship, may kindly appreciate here the complainant who had he had also made a withdrawn letter to the police officer in charge Itanagar saying that he doesn't want to pursue the case further, Lordship.
So that again will be trouble again.
So
Then again we'll proceed to next week, next to next week.
Lordship, this Lordship,
Let me see the record first. No? Let me see the record first. So to get some information, get some idea.
Yes, sir.
What had happened actually.
Yes.
No? So if nothing happens, we'll grant bail. Okay. Had Mr. Vijay Jammu, Land Council for the petitioner. Also had Mr. PA, Land additional PP. Okay, the. The case that is called for has been received. List this matter again on Monday.
Lordship, on Monday, whether hearing will take place or only the
Hearing.
No, hearing, just I'd like to see
Yes.
the record, because today there's no time, only for that.
Yes, Your Lordship.
There's no time, I just want to see some documents for which I don't have time now, today.
Lordship, in that matter, that can the matter be reserved, Lordship, since like enter the my friend
No, keeping reserve and everything, this today I have kept reserve, I need to
Yes, sir.
require some time to.
Your
take
Lordship,
those also.
we may be direct to retain the case there, Your Lordship.
Yes, yes.
That may be recorded, reflected in the order.
Let's see, list this matter on Monday.
Yes, sir. Oblige, sir.
Yes, that is to be retained.
Yes, sir. Oblige, sir.
Oblige.
Yes.
Your Lordship, this is IA for quashing of criminal proceeding arising out of Jumali PS.
IA? IA in what?
Quashing a petition, Your Lordship.
IA in criminal petition?
Yes, Your Lordship.
No, IA is for what?
For quashing,
for
Lordship. Quashing of the FIR, oh sorry, for the stay of the FIR, Lordship. Stay
What is
quashing.
this criminal petition for?
Criminal petition for the quashing of the
Quashing
FIR,
of-
Lordship.
And IA for?
IA for the stay, Lordship,
Stay.
because here,
stay.
Lordship, yes, Lordship.
Yes, Your Lordship.
There was no prayer in the criminal petition.
Yes, Your Lordship. We
What
inadvertently
was
missed out
charged
the
in criminal petition?
But here, Lordship, respondent number 2 and 3, Lordship, the service is incomplete, Lordship.
Okay. Just a minute. Any order passed in IA? Here also notice was issued. Service report still awaited. Okay. Then,
Your Lordship,
Mr. You are Mr.
P. Wangpan, Your Lordship.
Mandalani Council for the petitioner. As well as Ms. Lagelani. Petition PP is present. So, the service upon the respondent of 2 and 3 is still awaited.
Your Lordship, I beg to submit that, Your Lordship, the amount I'm alleged of being, that is already paid, Your Lordship. I have already paid all the amount, Your Lordship.
When?
Your Lordship, I'm alleged of dubbing an amount of 15,50,000, Your Lordship. Out of which 8,50,000 I have already paid, even complainant lodge a complaint.
No, when? After filing of this?
No, most of the money I have paid even before.
Before filing of this petition?
No, complaint, Your Lordship. Even before complainant lodge a complaint, I have already paid most of the.
No, what I'm saying, when this was filed, 2025. After filing of this petition, you have paid, or before filing of this?
No, it
petition?
was paid before, Your Lordship.
Okay,
I paid
then-
on installment basis, Your Lordship.
Yes, okay.
So, Your Lordship, may please come to page 59, Your Lordship.
Where is that? Where is the impugn order? You are you are praying for washing of the?
Quashing of the FIR also, Your Lordship, for staying the
FIR.
criminal trial, Your Lordship, which is pending before
Have
the
you received the
JMFC
record?
concern.
Have you received the record?
Lordship, no, Lordship, we have not called for the record yet, Lordship.
Then washing of FIR, how do we need to call for the records? Scan copy of the FIR is still under investigation, isn't it?
Yes, Your Lordship.
Then we
This
need to call for the record.
In the meantime, Your Lordship, this maybe stay, Your Lordship, criminal trial, Your Lordship.
Huh?
But trial is already commenced.
Yes, Your Lordship. Trial is commenced.
Trial already commenced.
Yes, Your Lordship. It is before
Then-
JMFC concern, Your Lordship. JMFC concern.
JMFC concern.
Yes, Your Lordship.
Then since you are praying for quashing of the proceeding, where
Yes,
have
Your
you
Lord.
stated? Just a minute, huh? Have you mentioned the case number? What is your prayer? Prayer for quashing of the FIR, then?
Yes, is staying the further proceeding of FIR
Okay.
at Jumali PS under section 120B, 420 and 34 IPC, Your Lordship. Same is pending before Honorable Court Judicial Magistrate First Class Consa, Your Lordship.
First FIR. Yes. Register.
The GR number they have not given, Lordship.
No, see. Yes, you have not given, you have prayed for quashing of the FIR, and then in the IA, what is your prayer in IA? What is your prayer in IA? In the IA also record has not been called for, then how do we adjudicate unless we see the record?
Little correction is needed, Lordship, because GR number they should have, Lordship.
It's there, I think.
Yes,
Your
Lordship.
Lordship, it's there somewhere.
GR number is in prayer portion, Your
Okay,
Lordship.
okay. Mr. You are P. Wangpan.
Yes, Your Lordship.
Mr. Wangpan. Okay, just a minute. It is submitted that the trial court record would be necessary for proper adjudication of this matter. Accordingly, let the record or be called for from the Judicial Magistrate First Class Consa. Okay. List this matter. You have taken step upon the respondent, private respondent.
Yes, Your Lordship.
When?
So actually, we took steps through advocate's clerk, Your Lordship.
Okay. No. But still, when it was first filed? April. Taken steps way back in April. It has not yet returned. Probably you may have to take fresh steps. You take fresh step.
Yes, Lordship, I
Okay.
will take fresh
If
step.
you want expedite trials. Okay. Okay. Then, after his present recording, record call for, then after record call for, in view of the office note dated 25/7/2025, Mr. Wangpan, learned counsel for the petitioner, praised for allowing him to take fresh steps upon the respondents. Prayer allowed. Steps upon the respondent number 2 and 3 by be taken upon respondent 2 and 3 by a registered post with AD as well as by usual process within a week from today. This is matter after 3 weeks. Okay.
Right.
Yes.
Hello, sir.
Yes.
The service upon respondent number 2 is still awaited.
Okay.
This matter may kindly
Mr. You are Mr.
J. Bate J. Koyu.
B.J. Koyu, learned counsel for the petitioner, who is present. The office note dated 37/2025 reflect that the service upon the respondent number 2 is still awaited in view of the above. List this matter after 2 weeks.
3 weeks. Sir.
3 weeks. Okay.
Next.
Your Lordship, on the last day, the records were called for only to ascertain the status of the case pending before the Judicial Magistrate First Class UAPA.
Okay. What is the status of the case?
Yes, Your Lordship. This is a criminal petition praying for quashing of the GR case pending before the trial court, only on the sole ground of mutual settlement. Only on the sole ground of mutual settlement.
Mutual settlement.
Yes, Your Lordship.
Offense
is
registered
380
against it?
IPC. 380 IPC.
380.
Yes, Your Lordship. The concern on the last date was that since there is only 3 witnesses in the case, why is it taken so long for the case to proceed? And therefore, the status of the case was
Okay.
required to be seen.
This was case of which year?
It is a case of 23, Your Lordship.
2023.
The FIR is 29/05/23.
Okay, page.
Page, Your Lordship, 12 to 15. Charge sheet is at 16 to 30.
It's a joint petition?
Yes, Your Lordship, it's joint petition. Here in the case, Your Lordship, the accused, after committing the offense, on the next day, he went himself to return this stolen laptop.
Okay.
However,
Very sincere.
it was done in a state of drunkenness, Your Lordship.
There is honesty in dishonesty.
Yes, Your Lordship.
Just a minute. Huh? So, where do we find that he has returned and he has received?
Charge sheet and 161 statement also, Your Lordship, of the accused person. Page number
22.
22.
Okay, recovered. Laptop in good condition.
It has been given on Zimma, the laptop.
Yes, I was feeling so sorry for stealing, so I decided to go to building from where I stole the laptop in case to return it back.
Okay. So, you dispose of.
Yes, Lordship,
Okay.
case provided.
So today we have no time. I'll keep it. We'll dispose. Mr.
M. Tangzang.
M.
Tangzang.
Tangzang. Just a minute. Madam Counsel for the petitioner. Also had Ms. Al-Bagir. Okay, since March, it has not been proceeded. Al-Bagir, then people. Okay, just for record, huh? Just write it and print it, okay? Yes, let me know. Once. Where have you stated? Huh? This is charge sheet. Okay, just a minute. Huh? Have you annexed the charge frame against the accused?
Yes, Lordship.
Where? Page
31.
31. Okay, so. And then this is agreement.
Yes, Your Lordship.
25.
Yes, Your Lordship.
Okay, and then how many witnesses have been recorded? You said
I believe your two have been recorded.
two.
Yes, the IO is remaining, if I'm not
Okay.
wrong.
That's fine. Huh?
Okay.
This will be disposed of. Huh? This is item
Deeply obliged, Your Lordship.
15. Okay. So we'll
Lordship,
refer it to the.
yes, we are agreed. Both the parties are agreed and first line discussion over.
Mr. Udeka.
Maybe refer to
Line counsel for the
Mediation.
appellant insurance company. I've also heard Mr.
MOPO.
MOPO. Line
sole
counsel appearing
respondent.
on behalf of the sole respondent staff. Huh? There is an element of settlement of the matter through mediation. According the matter is referred to the mediation for settlement through mediator. Okay, stop. The registry shall take steps upon take steps for referring the matter before the mediator for settlement of the matter through special in the special mediation drive mediation for the nation. Stop. Okay. Of So, yes,
I'm
Who is-
appearing behalf of tea time.
okay, who is for the respondent? Okay, can we refer this matter also?
Yes, Lord.
Okay, have you informed the other side?
No,
Not yet.
just instruct me, tea time has instruct me send to medicine.
Okay, time, okay, then what about the respondent? Jitalo. Okay, Mr. Tita, you are appearing on behalf,
Tea time,
you are Mr.
B. Sivo.
B. Sivo, Land Council appearing on behalf of Mr. T. Time, Land Council for the appellant insurance company. No one appear on behalf of the respondent staff. However, considering that there is an element of settlement of the matter through mediation, this matter is referred to the mediation center for settlement through mediator, through mediation staff. The registry shall take necessary steps for referring this matter to the mediation center for settlement through mediation. Okay.
Lordship, item number
They are
18.
Same, similar order. 18, okay. Yes. Yes, you are for respondent.
Yes, Lordship.
Who is for the petition? Oh, yes. Yes. What is this matter about?
My lord, here the case, the impugned order under challenge is the order dated 26/8/2024. At last page. Passed by the learned
Just a minute, the page,
at last page.
impugned order.
Yes, impugned order. 77, annexure 14. Against the interim compensation of 20%.
Against the,
This order is challenged against the,
okay, this is the impugned order.
yes, this is the
Page
impugned
77.
order. Yes, passed by
Passed
the,
by
learned
JMFC.
JMFC, whoever the learned court below has passed a 20% of interim compensation
Okay.
in the complaint case 121/2024 in
Yes,
NI case.
Yes, I now I remember. Now I remember, then you will take some time. So today, I think we have a paucity of time.
Yes, sir. Yes.
Then in that case, can it be posted?
My-
Monday, we have fixed
my- my
some
lord-
item.
My lord,
Tuesday?
we have discussed the regarding the date. So can it be taken up after 2 weeks?
No, Lordship, Lordship wants, we can fix it on Monday, Lordship.
No, Monday, we have fixed some fixed matter also. So when there is a fixed matter, I would like to dispose of. Okay, but then not Monday, Tuesday, can it be? Or if you wish.
My lord, I have
After
some
2 weeks
genuine
also.
difficulties, prayer commitments. So can it be taken up on the after a week?
Okay. Both the Lana Council. For the petitioner, Mr. Khan.
T. Sunil. T. Sunil. Takam Sunil.
T. Sunil. Okay, both the Lana Council. For the parties. No, just a minute. Mr. Hart, Mr. T. Sunil, Lana Council for the petitioner. And Mr. V. Jama, Lana Council for the respondent. So, on the request of both the parties, let this matter be listed after a week. After a week. Okay, let us make it then 2 weeks.
2 weeks. After a week, there
After
will be an increase.
Yes, after 2
Yes,
weeks. Okay.
Much obliged.
Obliged.
Yes,
Yes, my lord.
yes, Mr.
I have an instruction from Mr. Mangu. He has admitted that it can be, submitted for mediation.
Mediation.
Yes, my lord.
The earlier case is also listed for mediation. Okay. Mr. Ozing for the council for the petition. State is
And
also.
for state, yes, Lordship, yeah, state also there.
Also have Michelle Javier, petition PP for the state,
For respondent number 1, Lordship.
respondent number 1.
My lord, I am for respondent number 2.
And Mr.
O Pangam.
O Pangam, Lana Council for the respondent number
2.
2. So, there is a element of settlement of the matter through mediation. The parties have agreed for referring the matter to the mediation. Matter for to the mediation center for High Court Mediation Center for mediation. Son of the case stop. That the registry shall take steps for referring the matter to the mediation, referring the matter to the mediator for mediation. Okay.
Online Lordship.
Unlisted.
My lord, this anticipatory bail, my lord, in connection with Suzusa PS case number 06 of 2025, my lord. My lord, at very outset, my lord, I beg to mention, my lord, the earlier, my lord, on 29 2020 July, my lord, the bail, anticipatory bail application was filed before the session court SEPA, my lord. Subsequently, it was withdrawn, my lord, on same day, my lord, without considering the merit, my lord, on the request of the petitioner side, as there was a medical problem.
It was in which month you said?
No, there it was withdrawn, my lord.
Okay, when?
On 20 July 2029, my lord, 29.
29 July.
Yes, my lord. And this is how, my lord, and I'm
29 July,
informing.
yesterday?
Yes, my lord, it is, I'm informing that my day for yesterday. That's why I'm informing. Inadvertently, this order has not been annexed as annexed, my lord. That's why I'm informing at very outset, my lord. There was no answer because
would like to see the.
My lord, that's I'm having this order. And on a request, without considering on motion stage only, this was withdrawn because there was some medical problem on behalf of the from the applicant side. He was as taking medication here, treatment here, RK mission. That's why there may be subsequent problem. That's why, my lord, on request, it has been withdrawn, man. So now,
no liberty.
My lord, that was not there, my lord. Now, my lord, the fact is, my lord, I just highlight, my lord, brief fact, my lord. The fact, my lord, this on 24, my lord, paragraph 3 and 4, my lord, I have highlighted, my lord. Then 24, my lord, one Lucy Nabum, my lord, had physically assaulted one Lali Tachang, who is a disabled person, man. And because of this assault, my lord, he sustained injuries, grievous injury, and has been referred to the hospital for treatment, my lord. So, in retaliation thereof, my lord, at para 4, my lord, some relatives, family relatives of Lali Tachang, they had ransacked the house of Lesi Nabam and damaged the car of Maya Nabam on 25 July 2025 at around AM, my lord. This Lucy, my lord, in this regard, the father of Lucy Nabam, that is Nama Nabam, had lodged FIR, my lord.
Let us just see the FIR. Huh?
My lord.
So by name, even if you.
Yes, ma'am.
It will be confusion. Let us see the FIR first, then.
FIR is at page, my lord. There's two FIR, my lord. Page 20, my lord. Type copy 21, my lord. This lodged by Nama Nabam, my lord. It is to inform me that on 25 July 2025 at around 2 p.m. hours, Sri Thomas son, Ola Tachang son of Sri Mohan Tachang Tara, my lord, Port Ireland. My lord, my name has
How
been.
many persons?
My lord, here it 4 person has been mentioned, my lord.
Okay. Any others?
Any others? Yes, my lord.
Trespass.
trespassed, and so on, the others has illegally trespassed in premises, has entered inside my house and broke all houses. They said accused came to black tar vehicle number so 2 Naus of Das and Grand Betara. They also broke my Alto car bearing registration number so. Entered after incident, they left the spot and shouting, threatened to kill my whole family and also threatened to burn down house. Thereafter, they proceed toward Sri Adam Nabam resident and broke his car. Therefore,
he has also lodged FIR.
my lord, this subsequently, my lord,
Madam also.
Maya, my lord. Yes, my lord. This has been together, my lord. At page 22, my lord, I will request you to register this FIR and arrest the aforementioned accused immediately at the show.
And there is 2 FIR against us.
Yes, 2 FIR, my lord.
Okay, there was a 2 incidents.
My lord, the same transaction, my lord. Same.
It continues. Same no.
Yes, page 23, my lord, language is same, man. Page 23 type.
Maybe, but then they went with the same team, with the same, I think.
Page 22 and type copy 23, my lord. Again on same by Nabam, Maya Nabam, my lord. Wife of Adam Nabam, my lord. It is inform you that so and so. I heard some sound of fighting. Page 23, my lord. Went to see the matter, but saw that 8 to 10 boys were coming from Nabam resident toward my residence. I immediately entered my house. Accused started to broke my car bearing registration and also my scooty number. So they have threatened to kill my family and left the house. Therefore, I humbly request to register the FIR and immediately arrest Thomas so. I will. Mother, this is the FIR, mother. Now,
this was registered separate.
No, this has not been, my lord. This is already the first FIR has been registered, my lord, at page 20, my lord. Registered as Sijosa PS case number 0/2025.
And FIR filed by
This has been clubbed together, my lord.
Okay.
Please link with my lord at page 22, my lord. First FIR is page 20, my lord. This registered as Sejosa PS case number 06/2025. Then second FIR is page 22, my lord. My lord, see, please link with case number 06/2025.
What is your name in this FIR?
My lord, my name is Mohon Tachang, my lord. Mohon Tachang.
Is there?
Yes, my lord, it's there, my lord. That is why, my lord, my respectful submission, Mohon Tachang, my name has been wrongly implicated because I was not there even in the sport, my lord, at the incident's place, my lord. I was doing my duty here at Itanagar, my lord, at Jolong.
In both the FIR.
Yes, my lord. My lord, the first thing I have heard, my lord, that person, my lord, the first page 22, my lord. Type copy 23, my lord. The second FIR, my lord. Now, para 4 of my para 4, my lord, application, I've clarified, my lord, that part, my lord, because in any case, my lord, I was not there in the sport, even place of occurrence, my lord. I was here at Itanagar doing my duty. My detailment of duty, my lord, register I have annexed, and also the certificate from my commanding officer, my lord, on day of incident, right from 2023 to July 2025 to 25 July, my lord. I was doing my duty here at Jolly, my lord. Detailed chart I have brought into the record, my lord. It appears that, my lord, on misconception, my name has been.
Then this plea of LEY need to be inquired into.
My lord. My lord, they may take a statement of the commanding officer also, my lord. At page 24, my lord, will see my duty of detail registered on, my lord, guard, my lord, on Fort IRB. I'm a Fort IRB serving, my lord, constable, my lord. My lord, duty chart at page 25, serial number 2. That is duty chart dated 23/7/2025, 24, my lord. Mohon Tachang, my lord. Serial number 3, my lord. I was doing my duty at Itanagar, my lord. Jolly, my lord. And second, again at page 24, my lord. Serial number 9, my lord. Mohon Tachang. 24 to 25, I also, same I was in my duty place here at Itanagar, my lord. Now, the incident alleged to have occurred there at Sijasa, my lord. Pakai Kesang district, my lord. Now that affect, my lord, to substantiate my duty chart, my lord, at page 29, my lord, see, my commanding officer, my lord, have certified, my lord, issued the cert. This is to certify that Mr. Mohan Tachang, aged about so, District Arunachal, is a constable in 4th IRBN, had performed his duty on 23 July 2025 to 24 July in the 4th IRBN BH headquarter, Joli, my lord. Again at page 30, my lord. On 24 to 25 also I perform my duty, my lord. Page 30, my lord. This is to certify the Mr. Mohan
The
Tachang.
incident took place on 25 only after
25, my lord, 25.
after you perform duty.
No, my lord. Because 25, my lord, incident happened
On
25 of the 2 a.m. my lord. Morning, my lord. It is not possible, my lord, because I was there in 25, my lord, in my duty place only. And apart from, my lord, whosoever has been, whose name has been reflected, my lord,
Duty where you said?
at, my lord, Joli, my lord, at
Joli.
headquarter, my lord. IRBN headquarter, my lord, at Para 4, my lord, I have stated, my lord, of my application, my lord. Although in FIR, my lord, 4 person was mentioned, 5 has been arrested, all the person who has been arrested. But my case, my lord, I was not there, my lord.
Incident happened on 2 a.m.
Yes, my lord, 2 a.m. And their FIR also, my lord. So
yes, in other, lordship, in another FIR, it's 2 p.m. lordship. Both are contradictory, lordship. In first FIR, incident happened at 2 p.m. lordship, and in
2 p.m.
Yes, page number 20, lordship.
Okay, it is 2
Page
p.m.
21 is read type copy, lordship. It's 2 p.m. lordship. And
The other one when copy
again come to the
PM into a appears.
And in FIR, the page number 23, lordship, it's 2 a.m. lordship. Both are contradictory, lordship. And lordship, kindly revisit the page number 27, lordship.
Just 2 minutes.
So this is the attendance register, lordship. Determined serial number 9, lordship.
Just a minute.
Page number 27, lordship.
27.
Yes, lordship.
What is that?
Serial number 9, lordship. This is the attendance, lordship. 9 is Mohan Tachang, lordship. Duty hours 17 hours to 5
p.m.
5 a.m.
AM morning, man.
AM morning.
Yes, man.
Yes, 5 p.m. to lordship. 5 p.m. to 5 a.m. lordship.
Yes.
So if incident happen in 2 a.m., then statement of petitioner is lordship.
This was
right.
when?
But if
detailment.
But if incident happen in 2 p.m., then there is a possibility of say involvement, lordship. So at this is stress, the CD may be called for lordship.
Malad in the FIR, Malad was seen, Malad 2 a.m. Malad. That is practically, Malad, it's not possible, Malad. They have stated, Malad. So since I am a constable, Malad, they can take, Malad, if anything happen, anything revealed there in CD, might involve, Malad, Malad, any action they feed him like they may take, but as of now, Malad, since because of this, Malad, misconception, Malad, I'm serving as a constable, and if anything, Malad, arrest, Malad, my service will be jeopardized, Malad. That's why, Malad, I brought. The second, in the interest of
if you are involved, you have to face the consequences.
Yes, my lord. I duly agreed, my lord. obliged, my lord. Only for my lord till production of CD, my lord, I may be given interim protection. My lord. That's only my in the interest of justice, my lord. If anything reveals, my lord, maybe cancel, my lord. At least in the interest of justice, because my service career.
Mr. T. Tabu, Land Counsel for the petitioner. The petitioner filed this application under section 482 of the BNSS 2023, paying for and seeking grant of pre-arrest bail, apprehending his arrest. How many applicants are there?
My lord, only one, my lord. Is Mohan Elias, my lord, is been.
Okay, apprehending his arrest in connection with Sijosa Police Station, PA Police Station case number 06/2025 under section 324(5). 330. What is this 331?
31, my lord.
This is BNS.
Yes, BNS, my lord.
What is 324?
House trespass.
324, my lord.
331. What is 331?
331, my lord.
House trespass.
House trespass, my lord. House breaking.
332.
332 is for
331(4),
house trespass, but in order to commit
332, 351, 3 within bracket 3, BNS 2023. Claro. The prosecution case is that one Nama Navam lodged an FIR before the officer in charge, Sijosa Police Station, on 25/7/2025, alleging that on 25/7/2025 at around 2 p.m. the accused applicant Mohan Techi Tara along with other co-accused persons illegally trespassed in his premises, entered inside and broke all the house, damaged the house stuff. They also broke they also damaged his Alto car, and after committing the offense common, they left the spot by shouting, by threatening to kill his whole family, and also threatened to burn down his house. So thereafter, the accused persons proceeded towards the resident of one city, Adam Navam, and broke his, and also damaged his car, for which a separate, and then broke his car, huh? Okay, stop, huh? Based on the above FIR, the police has registered the aforementioned Joseph PS case number 06-2025, 06-25 under section same, okay? 324-5, 331-4, 332, 333, 351-3, BNS. So whether, okay, and since the accused applicant is the named accused in the above, in the aforementioned FIR, he is apprehended, there is a reasonable apprehension that he may be arrested and cause unnecessary harassment. Stop. Okay, just a minute, huh? Before this, huh? One small paragraph. The case, it is submitted that the accused is what he is.
He's a constable serving in IRBN,
Is
Port IRBN.
He is a government employee working
as
constable in under in
Fort
constable,
IRBN.
government
Headquarters
employee working in Fort IRBN.
Yes.
IRBN and presently posted at
Headquarters Joli Malab.
Headquarters Joli.
Itanagar.
And on the alleged incident, he was on duty from where
20, my lord, at page 5, my lord, 23 July to 25 July, my lord. I was attending duty, my lord, at Port IBN headquarters, Joli, my lord. Para 4 at relevant page 5, my lord.
Okay. Was on duty from 23/7/2025 to 25/7/2025, attending his duty at Fort IRBN headquarters at Julie. And thus he is nowhere involved in the above incident. However, since he is the named accused in the above FIR, he has a reasonable apprehension that he might be arrested in connection with the above police, Sejusa police station case staff. Hence his bail application staff. Call for the case study, issue notice, since Mr. Lloyd PP, appeared and accepted notice on behalf of the respondent. No formal notice need be issued. List is when can you call for the scan copy of the case study? Okay.
We are on 18, Lordship.
Okay, list is matter again on
18.
18.
Yes.
18.
Since Lordship,
August.
there is a Jubilee celebration ends.
Okay. In the meantime, in the event of the accused Mohan Tacham, alias Mohan Techi. In the meantime, it is provided that in the event of the arrest of accused applicant Mohan Tacham, alias Mohan Techi, he shall be release on interim anticipatory bail on execution of bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority with the further condition that he shall cooperate and appear before the IO of the case as and when called for, and that okay, that's enough. Huh? As and when called for. Okay, and that he shall not hamper or tamper with the evidence of the case in any manner. Stuff. Huh? List it. Huh? List this matter again. Huh? 18. Okay.
Deeply applied.
My lordship.
Yes.
Lordship, by order dated 22/7/2025, page number 10, lordship. Lordship has pleased to pass the direction to the respondent authorities.
Okay.
To dispose of the pending representation within 3 weeks. But Lordship, here in the direction, representation is pending before the respondent number 2, not respondent number 6, Lordship.
Huh? Respondent number
2, Lordship. But
where in which para?
Lordship, page number 12, para 8.
Para 8.
Yes, Lordship.
Respondent para 8.
Yes, Lordship. Para 8.
Oh, respondent number not 6.
Not 6, Lordship. It is pending before respondent number 2, Commissioner Educated.
2.
Yes, Lordship. So this has to be changed, only altered, modified.
Okay.
In place of 6 only.
Mr. Ingo, Learning Counsel for the applicant. Also heard Mr. Togong, Learning Counsel for the respondent.
Yes, my lord. Standing counsel for education.
Standing counsel for the education department. Staff. It is submitted that at para 8 of the order dated 22/7/2025 passed by this court in WPC 322/2025, there is a typographical mistake which is typed as respondent number 6 instead of respondent number 2. Stop. By filing this IA, the petitioner seek correction of the said said error. Typographical error, not mistake. Okay, error. By filing this IA, the petitioner seek correction of the same stuff. The prayer considered and allowed. The respondent number 6 and the direction, just a minute. Okay, the respondent number 6 in para 8 of the order dated 22/7/2025 stands corrected as respondent number 2. Okay?
Yes.
With the above this IA stands disposal. Okay?
Deeply.
Thank you.